Friends, I just pressed the let's go live button, which means you know what we got to do. Wait for the stream to fire up all across the fruited plain of the internet. It is a Monday. We got a holiday week ahead. Man, it's Thanksgiving already. I can't even believe it. But we can't jump into the holiday festivities until we can get started. And we can't get started until the tubes are connected. I've got to make sure the tubes are connected. It looks like they are alive and well. That's tremendous. We can go ahead and get started. That's great news. Let's go ahead and do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Judge Engoron. You know him from New York. He is now denying Donald Trump's motion for a mistrial. And we knew this was coming, but of course we got to go through it because they're going to be appealing this, and they've already appealed and actually suing him, asking why his gag order and a bunch of other stuff is appropriate. And so we're going to be following this one around. This is Judge Engoron. You may remember him from these very close proximity photos. Him and his law clerk, Allison Greenfield, also known here as the judge's GF. And there's a little distance between the two. I mean, it looks like that. You can see their computer screens are basically kissing each other. And so we're going to be talking about these two because the judge says he has absolute discretion with his GF. And if he wants to do something with her, if she wants to whisper in his ear, pass him a love note, whatever, well, they're free to do that because, as we've talked about here, Judge Engoron and his law clerk, according to New York law, according to Engoron, they have professional interchanges. You know what I'm saying? And so he's got absolute discretion over his professional interchanges and also his areolas and other things. So we're going to talk about that today. He's got several things we're going to go through. One is the denial. So he actually put out this order, deny. He will fly through it. And there is a lot of cope in this, man. I mean, he is really trying to paper over his GF's behavior because remember, she made a lot of donos over to the left. And he back calculates this. He's like, well, I mean, if you think about the hotel costs and about this cost and about this cost, and you deduct it from this and you deduct it from this, the $3,000 that she spent over on Democrats isn't really worth all that much. And so everybody just relax. He's saying a bunch of people are making a bunch of heyday about nothing, a bunch of, ado about nothing. And so we'll see what Engoron says in all of it. But I do want to briefly just go back through the motion for a mistrial just for some context. And then we'll see what's going on over from the day's trial. Of course, we've got the trial activities are taking place today in New York. Adam Klasfeld is there reporting. And I think we had an interesting witness there today. I'm not exactly sure who it was, but we'll go through and see what happened today. Of course, we're in, I think it's week 8 now. Oh my gosh, of Tishy's trial. Now, speaking of long trials, my friends, we've got a little bit of a thing happening over here in Georgia. And over the weekend, Fani, you may know her as the biggest Fani in Georgia because she's the attorney general for Fulton County and for the state. And so what she has, or the biggest prosecutor, no, she's the biggest, yeah, what is she? No, that's Tishy. We're getting them all confused. She's the biggest county DA in Fulton County. And so anyways, big Fani. So the point is, she is here saying that they're going to be scheduling a trial for August sometime in August 5th. Now that's pretty curious because we've got the election in November. Okay, so August, September, October, November. Not too long away until we're going to be voting. And we know the DOJ's got certain policies, like 60, 90 days, 180 days, whatever. Like they didn't let us do anything to talk about Joe Biden and his criminality because the DOJ said, oh, we're too close to a federal election and we don't want to interfere with the election, But Fani is wanting to schedule this on August 5th. Okay, she filed a motion to schedule the trial for August 5th. Now, the problem with that, obviously, is not only is it in August, and so just to theorize and game this out, we've got March, May, and August all on the table. So all of next year will be Trump in trial if Fani gets her way. And the issue with this is that Fani says that these trials, okay, all the RICO case, and there's 14 co-defendants left, they're going to go through 2025. Okay, so just we can do the math on this. Several months, if we are in August starting and we go into 2025, that necessarily means we're going to be in trial during the election in November if Fani and the left get their way. So we're going to be pounding the table about that right now. And then lastly, we're going to be talking about what's happening out of the D.C. Circuit Court of Appeals. Now, I know many of you may have listened to this, but we're going to save it for the last segment in case you don't want to listen to it again. But we're going to go through it because there's some actually good stuff here today. And I think, this is just a temporary stop, right? This is on the way to the Supreme Court. We're definitely going to have a lot of these issues land at their doorsteps because I don't think that whatever the outcome is here, I don't think that either side is going to be happy about it. But of course, Judge Chutkan issued a gag order saying Trump can't talk to any reasonably foreseeable witnesses about anything reasonably foreseeable that's reasonable to her. And you go, what? That's not very reasonable at all, because it seems like Trump doesn't know who the witnesses are, doesn't know who he can talk about, and there are problems with that. And so they're challenging this. Of course, they appealed the gag order. It was in the Court of Appeals today in front of these 3 judges. And we actually got some pretty decent clips here. I mean, we have Judge Millett, an Obama appointee, Judge Pillard, Obama, and Judge Garcia, Biden. But it wasn't like as a slam dunk as you may think. Because we have the First Amendment and stuff, and it's like obvious on its face. It's like it says free speech, like right there. But anyways, the DOJ can't figure it out. So we're going to hear from 2 different people making arguments today in the D.C. Circuit. We've got this guy, John Sauer, who was arguing on behalf of Donald Trump. A couple clips from him today, and then a couple clips from the government. And I actually want to spend some serious time on this clip. We listened to a little bit of this morning on our members only stream this morning. So membos, if you're out there, we're going to listen to it again. But it is, we sped it up this time. Okay, so all speeds are at 1.25 speed. So if you're listening today on an advanced speed here, so let's say you listen to Rob at like 1.5 because you're like, oh, Rob, he talks so slowly, he's so boring. You got to speed it up. And I turn into Chipmunk. Well, you're going to be listening to maybe 1.75 when we get to the audio. And so that's fine, I know. I can drag on and on and on. Trust me, I have to live with myself. I wish I could speed it up myself. I can't. Here, so we got 3 segments to go to. And we're grateful that you are here and with us. It's Thanksgiving week, my friends. Hopefully you got your turkey plans planned. And fortunately for me, I can delegate all that stuff to Mama Govea. Love you, Mama. See you this week. And shout out to our mamas and papas out there, all the people doing all the heavy lifting on the turkey day. But we're going to be here this week cranking through what's going on out there. We got 3 good segments here today. We had a beautiful members-only stream this morning. We love our members-only streams. And so we did that this morning at watchingthewatchers.locals.com. We talked about what happened in Argentina, which was amazing. Shout out to Javier Milei winning down there. I mean, the left is freaked out about it. Like, oh no, what if that happens here? We're all going to die. And so, hopefully it does happen here. We take over from the lefties. But pretty exciting stuff. We talked about that. We also had a fun conversation about Joe Biden and his birthday and about how he's failing pretty dramatically. And so we talk about some other good stuff on our members-only streams. YouTube members, we're grateful to have you aboard as well. You get all that stuff. The only thing we ask is you join us for our after party, that you grab the members-only link on the community tab section on YouTube. So grab the Telegram link. That's where the after party is. Otherwise, we'll see you there on the after parties. We do member-only streams, and we do a lot of fun stuff. So come check it out, watchingthewatchers.locals.com. We've also got our website, robertgovea.com, which is where you can get the daily show reports and the daily newsletter. Okay, so if you go to robertgovea.com, click the reports button, you'll see we turn all the segments into segment and reports. So you can read about it, and you can actually read and get the PDFs, get the lawsuit, all the stuff here. So like, for example, this was a full segment. It's right here. But you can also read a summary of what we talked about in the segment in case you're like, I don't have time for all that. Then you can also grab the PDF and the red lines, all available at robertgovea.com. Not Rob. Hello, Rob. It's you can't abbreviate your website. Hello. So go to robertgovea.com and grab the website and join us over there and get the newsletter. Sign up for the newsletter, of course, because we want to deliver all the stuff to your inbox. All right. Now, let's get into it because we've got some meat and potatoes to attend to before we get our turkey and more meat and potatoes. Let's get to it because this is, of course, some fun stuff. Judge Engoron claiming absolute immunity with his law clerk. We know her as Allison Greenfield. We call her GF here, short for her last name, Greenfield, and maybe the judge's feelings for her, we don't know. But the judge, as you can see, is sitting right next to her, and she has been the subject of a lot of concern throughout this entire trial, largely because she's passing notes after every objection. Trump's defense team, Alina Abba and others are saying, why do you keep whispering? And the judge gagged Trump's defense from commenting on it. Okay, why are you talking to her, Judge? You're the judge, not her. And she said, you can't talk to me about that. Don't even file a motion. And when they said, we're going to file a motion, the judge screamed and scolded at the defense and said, don't do it, Chris. I go, what the heck's going on over here? So then Trump, of course, filed a motion for a mistrial. And we talked about that. We did a full review on it. We're going to go through just very briefly for context what was in there. But then we're going to take a look at judge's order because he's denying the motion for a mistrial. He's like, no, we're not going to do that, obviously. I have total, absolute discretion with my GF. And we know that previously he said that he's entitled to have professional interchanges with her, whatever that means. So we're going to talk about it today. And then we're going to see what's happening in trial because Adam Klasfeld was there in New York after this ruling came out. We'll see what is inside of all of it. But just as a reminder, this is what the original mistrial motion looked like. In fact, it is loaded up right here. And there was some good stuff inside. We redlined this whole thing pretty clearly when we covered this in a prior segment. But just for context, okay, this is Trump saying that there is some serious misconduct here in this case, Judge. And he gave us a bunch of stuff that we redlined here saying that all of this is really emanating from the judge's bias and that a mistrial is completely appropriate. First, Judge Engoron was including some very interesting links to articles to CNN, Washington Post, and other entities like NPR, Above the Law, and he was putting these articles in his newsletter that he was sending out to his Wheatley alumni organization. And in fact, some of those emails had what he called bonus torso photos, which had, unfortunately, a picture of the judge's bare chest. Now, we also analyzed this. Okay, this is in Trump's mistrial motion, which we covered fully. But you can see this close proximity between the two of these little lovebirds here. It's like, what's going on over there? Why are you talking like this the entire trial? And what happened was, when the cameras were on them in the courtroom, they turned the cameras so that nobody could see what they were actually doing with their hands, you know, under the desk. And we're going, oh gosh, keep your hands above the table, okay? Look, you two, we don't know what you're doing under there. So they turned the cameras. All right, now this is all in this motion. And of course, there's some improprieties that people have there. We also know that the gag orders are clearly a violation of Trump's First Amendment rights. But we also know that there was considerable tension in the courtroom and that there was an opportunity where Chris, Trump's defense, said, we're going to move for a mistrial, Your Honor. We're witnessing misbehavior from you. And we are Trump's defense team. We have an obligation to raise an objection on behalf of our client. Otherwise, we're going to get in trouble. And when Chris said that, the judge scolded him and said, don't file that motion, Chris. I love her. And they said, this is out of control. Now, also, this is very important stuff that I wanted to make sure we had. Okay, this is Allison Greenfield's dono forms. $200 to Freedom Democratic Clubs, $175 to Chelsea Reform Democrat Club, $350 to the West Side Democrats. Judge Engoron is going to cope his way through this. He's like, well, and he's going to explain it. Like all of these are deductible and it's not consequential. So here, $210 to this one here. Okay, it turns out thousands of dollars, all right? Over $3,000, over $3,900, I think, between the 2 years. And it's a lot of money. Now, part of the problem here is she was making these donos while the action was pending, And some of these donos, right, Trump is being prosecuted by Letish and Tishy James in New York. And these groups were actively supporting the attorney general. Okay, so the law clerk who's going to be hearing the case against Trump is making donos to support Tishy Letish in New York. She was also attending political gatherings, engaging in partisan activity, and so on. We read through the whole thing, and so I don't want to belabor it here. Please watch that video if you missed it, because this thing is just a mess, all right? The amount of corruption and disgusting behavior inside this is bad. But the judge is going to cope his way through it. He's going to say, well, you know, it's all basically within my discretion, and you don't get a mistrial. And so this was previously filed by Alina Abba and, of course, Clifford S. Robert, who submitted an affidavit previously saying, Judge, I've been here. I've been practicing law for a long time. I've never seen anything quite like this. And so we, of course, are going to go into this because Engoron denies the motion for a mistrial. We'll get right into it. But first, a quick message from our friends and sponsors of this show. And now, We're back. Engoron denies the Trump motion for a mistrial. We're not surprised about it at all. We're going to go through it in detail, and then we're going to see what happened in the trial after we read through this motion, because trial's back in session. Engoron is just marching forward. Letitia and the rest of the people there on behalf of her just prosecuting ahead. And so here is what we see filed out of the Supreme Court of the state of New York, County of New York. The case, of course, is Tishy Letish and the people versus Donald Trump and everybody else's entire extended family. So this is President Engoron, right? And he's asking himself whether I'm going to be granting this order to show cause. And this was a vessel. This was the mechanism by which the defense was asking for permission, essentially, to the court to make their complaint. They said, Judge, how do you want us to address your weird footsie games and your love notes with your court clerk? Just let us know. And he said, well, how about an order to show cause might be the right way to do it? And they said, all right, we'll file it. So here's what it looks like. Now, the judge, they filed it. That's the motion we just read through with the red lines. And here's the judge's order on that. And they were saying motion for a mistrial. We need a new trial, right? This whole thing is so bad that we got to do it over again. So the judge says, all right, you whiny Trump lawyers. Says, upon reading and filing the affirmation, this is what Clifford Roberts submitted, and also reading the affirmation of David Demarest, and also the memorandum of law that we read through previously here, and upon all the pleadings and proceedings, and sufficient cause having been shown. They say here, okay, so this is an order, that is not going to be signed. All right, so the judge is declining to sign this for the reasons stated in the order annexed here too. So the judge, this is kind of an interesting thing that he's doing. So I'm not going to sign this. He's saying, let the people of the state of New York, through Letitia James, show cause before this court on why an order should not be made and entered granting a mistrial. Okay, so they're basically submitting to the judge a blank order, right? Hey, submit it as an order to show cause is kind of when, in Arizona, the way we use it is kind of like you're in trouble. The court is asking you to come up and do something, like your case is problematic, other side respond. And that's what they're asking here. So Tish, they say there's a motion for a mistrial. The judge wants to hear arguments on this. You need to show up and explain why there should not be a mistrial under the law and granting such other relief that seems appropriate. Ordered that opposition papers are served and all the things, right? The judge could have set dates on this. Could have said, okay, this would be on the 27th day. This could be on the 31st day. And then the judge is making a little correction here. He's inserting that. He says, by e-filing the same on this day, let's say, the 30th and whatever. But the judge is saying, I'm not going to sign this order. Right? I know Trump's defense, you want me to, like this is a prospective order, but I'm not going to sign it, and here's why. I am not going to be granting a mistrial signed off here by Judge Arthur the Engoron. This is his order, declining to sign. Judge Engoron declines to sign Donald Trump's proposed order to show cause for a mistrial. The judge writes, he says, this court declines to sign Donald Trump's proposed order to show cause, seeking permission to move for a mistrial. Now, they say the law provides that at any time during the trial, the court, on motion of any party, may order a continuance or a new trial in the interest of justice on such terms as may be just. And Trump and his supporting papers, they argue that a mistrial is necessary because essentially the court has exhibited bias. Judge Engoron. He says, 1, directly bias, as I publish a high school alumni newsletter with links to articles referencing this case, which he did. And we read through those articles here on a prior video. And on this channel, we have our videos organized into case playlists. So if you haven't seen anything or you're missing something on the New York trial, go to the homepage. You'll see the playlist there for New York. You'll see all the New York videos there. Same for the other cases. So we talked about this. We actually went through the newsletter with the bonus torso photos and the links. And he was saying, man from, he was, class of 1932 or whatever. And he said that I am prosecuting Trump. Yay, look at me. So directly through the newsletter and indirectly through my principal law clerk, known as Allison Greenfield, really the star of this whole show these days. Like, she's like the main crux of this case now. Allison Greenfield, the judge's GF, whom they allege violated New York law by exceeding the permissible amount of political donations in a calendar year. And we saw that there's a lot of donos that she made. We saw the whole spreadsheet of them. The judge says, well, as an initial matter, to the extent that Trump's arguments rely on alleged, quote, facts, the judge says in parentheses, facts, in quotations, says based upon editorial opinions that denounce plaintiff's case, such opinions are irrelevant and of no evidentiary value. So they say that Trump's facts are just, quote, facts. They're not really things. They're based on editorial opinions, and they denounce Tishy's case. And so they're irrelevant, and they have no evidentiary value, which is nice that a judge can just say that. So they say equally irrelevant is the, quote, expert affirmation of yet another retired judge. And so what happened was, in these affirmations that we read through previously, they were saying, Your Honor, like I've been practicing for a long time, never seen anything like this. The judge sits on the top of the bench, the witness sits below because the witness is below, and then everybody else sits below that, right? The jurors are down here and the clerk's over here, and like the judge is of the highest level for a reason. I've never seen anything like that. This is just one example of some of things they haven't seen. And so they brought them in and they read them in. The lawyers read them, judges read them. Never seen anything like this, Judge. So he says, oh, another retired judge who's not even on the bench anymore. His name is David, says Engoron, who states that he was, quote, retained as an expert by Trump's counsel to opine on the legal basis for a mistrial. He says, I don't care about this guy, in quotes, as I explained in my September 26, 2023 decision. Granting partial summary judgment, legal arguments are for counsel to make and for judges to decide. And therefore, says Engoron, such an expert affidavit is neither necessary nor permitted. I'm not even going to read it. The rule from prohibiting experts from providing their legal opinions or conclusions, quote, is so well established that it's often deemed a basic premise or assumption of evidence law, a kind of axiomatic principle. And he cites another thing, says precluding expert affidavits on the law. He says it remains black letter law that expert legal testimony is not permissible. Expert legal testimony is not permissible. Okay, so what they're saying is you can't bring in an expert on the law. I am the law, says the judge. I decide what's going on in my courtroom, and you can't criticize me for your interpretation of the law. Like, that's really, honestly, what the Court of Appeals is for, right? That's Court of Appeals can come in and then reverse that. So a bunch of experts aren't going to come in here and dictate to a judge how this goes, which of course is true. Like, that is how it works. But they're trying to make the point to the judge to give them permission to even move forward with the motion for a mistrial and submit this and have Tishy respond and have arguments on it and the whole thing. So he's just saying you can't, they're using it almost, I would say this, as persuasive authority, not mandatory authority that they have to follow. So it's not precedent, right? It's not precedential that they have to follow it. It's just, hey, judge, by the way, other experts who watched a lot of trials, they also say you're out of control. So they say this court has already cautioned Trump's lawyers against submitting, quote, expert opinions on purely legal issues. He's like, don't question me. I already know what I'm doing. How dare you? Moreover, as detailed herein, former Judge Demarest, David, he says, his expert opinion, this retired judge, it incorrectly summarizes the relevant law, idiot, and fails to address all the applicable governing ethical guidelines. So the judge says, I'm way smarter than him, and I'm still a judge. And I have a principal law clerk, does he? Now he says, Trump correctly asserts, now we're getting into the thousands of dollars of donos that she made. They say Trump correctly asserts that the New York Code generally limits to $500 the political contributions that members of a judge's staff may make annually. $500. Now, we already saw that previously, right? The dono amount is pretty significant, kind of a lot more than that. As we saw here in the original filing, there's a whole spreadsheet of these things, and the spreadsheets have a lot more than $500. You saw this one right here. 250, 250. There's 500 bucks between these two right here. And these went to the same organization. Look at that. First one we looked at. 250 on 6/1, another 250 on 6/1, 2022. Allison Greenfield made 2 donos, 500 total to Jim Olis Liberal Democrat Club. Right there. And another $100 to Sivin. Another $100. Sivin. New York County, 25. Those are smaller amounts. 100 bucks here, 250 here. Jim Oles. Okay, so boom, Jim Oles has 750 right there. Right, we've already got that one, just taking a quick look at that. So he's 750, 3 donos right there to Jim Oles. Now, there might be even more. So she's already, with one person, broken through the $500 barrier to one recipient. Now, it's much more than that, right? It's not only one recipient, but 200 here, 175 here, 350 here, 50, 50, 50. In aggregate, it's $3,900. So let's see what the judge does to get rid of this one. He says, yeah, it's true. It generally limits the political contributions to $500 that they may make annually. So from this, now the judges, let's see what the judge does with this. But they say, it looks like total, okay, $500 total, not per person. It's not like you can get 500 to candidate A, B, and C. No, 500 total. You either give it to all to one or, you split it between the 3 of them. But they say, okay, yeah, the judge is like, yeah, it's true. Trump is right about that. However, says the judge, Trump and their, quote, legal expert, in quotes, they fail to cite the applicable unambiguous ethical guidelines for, quote, candidates for judicial office. So she was running for office at the time. So that is found in Judicial Ethics Opinion 9819 footnote 1, which is just hysterical, okay? So he's referencing to a judicial opinion, which is an opinion interpreting the rule. The rule says this, it's $500, right? So facially, it's clear, but he's going and finding some other thing. Let's see where he goes with this. He says, since 2020, my principal law clerk has been pursuing elected judicial office. Wow. So that means you can just pursue elected office for years and lose and just do whatever you want, is skirt the rules, break the rules? That's nice, Judge. It looks like it's a little bit of maybe an escape hatch in the law. Says here, my principal law clerk since 2020 has been pursuing elected judicial office. And as the governing ethical guidelines for the law contemplate and expressly permit, indeed, as the judicial opinion clearly states, the $500 limitation on political contributions does not apply to an appointee's contributions to his or her own campaign. What? Nor would there be such a monetary restriction on the purchasing of tickets to political functions. Okay. Well, she made that dono to Jim and Chelsea Reformed Democrat Club, and New Yorkers for Alex Boris, and other people, Tom Sylvan and others. Jim Oles, Liberal Democrat Club. Though that doesn't sound like it's going to her. Let's see where the judge goes. Says, now when deducting the price of tickets to political functions that my law clerk attended from all the contributions to which the defendants cite, that whole list there, the remainder is still well below the ethical and legal permissible annual limit. What on earth did he just say? So, do you have receipts for that, Judge? Do you have a spreadsheet to show us the receipts on that? He says, when deducting the price of tickets to political functions, so he is trying so hard to make this fit, it's embarrassing. It's actually embarrassing. This is like an F in law school. You fail. Okay, nice try. But you fail. So you're saying, wait a minute, what? That she bought tickets to political functions. The price of the tickets to the political functions that my principal law clerk attended, from all the contributions to which they cite, the remainder is still well below the legal and permissible annual limit. She says Trump further attempts to argue that since my principal law clerk attended events sponsored by certain organizations, also legally and ethically permitted, each and every separate action and position of those organizations should be imputed to her and by proxy to me. Well, that's what the rules say. It says members of a judge's staff. Yeah, so it's you. You're the judge, I think, unless she is. We don't really know. They say such arguments are nonsensical. Would you like to explain some more? In any event, they are red herrings, as my principal law clerk does not make rulings or issue orders. I do, says the judge. It is just wild. So he says, I'm not even going to address these arguments. Now, again, I'd like to know what he's specifically talking about. Okay, we have a spreadsheet here that shows what these donos are. So she made money to political organizations. And I guess those were like tickets. Those were like tickets to those events. And she's allowed to buy tickets to events. So, right, so she's allowed to buy tickets. So she makes a $250 dono. Let's just go back to Jim Ola's. $250 right here, $250 right here, and $250 down here to Jim Ola's. Right there again, $250. So we've got receipts for that. So that is over $500. So I guess he's saying that if she went to, I guess, 3 different events for him. And what did those tickets cost? I don't know what they cost. Like there should be a dollar amount, right, from Jim, because she put $750 to that guy. And I don't know what the tickets costs. But that's how she is being allowed to deduct it. Okay, she's allowed to purchase tickets, go to political functions, and it was just like, it's like carbon credits, it got offset. So she's allowed to deduce it. It all evens out. Now, if the judge says that, I'm fine, but can we see the receipts for it? Like, do we have a ledger? Can he put that all down on the books for us? But he won't do that. The remainder is still well below the legal permissible annual limit. So if she spent $3,000, it was $2,500 in tickets. Incredible. But he's not going to deal with it. Not going to really, he says they're just nonsensical. And they teach you this really in any writing, right? Anytime somebody just says like, clearly, this is true. Well, you have to explain it. It's not clear. Like, you need to tell us. Such arguments are nonsensical. Well, why don't you explain it? He doesn't. He just says, and in any event, they're a red herring because I make the rulings. Okay, well, is your law clerk still in violation of the law or not? So he says, I've explained on the open record, I have pursuant, oh, here he goes, man. He's getting into it now. I have, pursuant to the law and advisory opinion from New York, an absolute unfettered right to consult with my law clerks, oh, gross, in any way, shape, or form that I choose. Oh, gross. He says a judge may consult with court personnel whose function is to aid the judge in the carrying out of the judge's adjudicative responsibilities or with other judges. Unfettered, absolute, unfettered right to consult with my law clerk in any way, shape, or form I choose. Even if that includes love notes, even if that includes playing footsie, we don't even know if she's giving him massages or whatever. Her laptop is right there. She's literally co-judging the case with him. He's consulting with her repeatedly throughout the trial. Like, I joke about some of the more, jokey things, but seriously, why are there 2 judges up there? It's not a joke. The judge should be able to handle this on his own or not. And as Alina and Trump's defense have said, they are watching the judge change his opinions mid-opinion. They'll listen to the objection. The judge will say, that sounds pretty good, until she gives him the side eye and says, you're sleeping on the couch tonight, buddy, if you do that. Okay, sorry, sweetheart. So then he makes a change and they say, enough already. And every time, like if the judge wasn't doing anything wrong, why is he screaming at Mr. Keese about this? Why are they moving the cameras around so that you can't see what they're doing, so that the press can't see it? It's because he knows, right? And he's panicked about this. And I think he's digging the hole deeper, okay? Every single time he writes an opinion like this, it seems more and more ridiculous. Even the Court of Appeals is going to go, bro, can you just stop talking, please? Like, let them talk about your law clerk. Just let them talk about it. What are you so freaked out about? Just stop playing footsie with her. So the judge says, all right, however, as I have made clear over the course of this trial, my rulings are mine and mine alone. There is absolutely no co-judging at play. Well, then move her out from under you and stop taking her notes. That I may consult on the trial record, the law, and the facts before issuing any respective ruling is within my absolute discretion, and is in no way evidence that the final decisions are anyone's but mine. Accordingly, there is no factual or legal basis for a mistrial based on the allegations against my principal law clerk, my GF, my Greenfield. Now, to the extent, writes Engoron, man, he's really upset about this, to the extent that Trump argues that I've exhibited bias by stating in court when he said this, I'm not here to hear what Donald Trump has to say. When he said that, Trump was on the stand, Trump was talking, and he said, shut your mouth. I'm not here to hear what Trump has to say. We're all looking at each other like, he's on the bench in a courtroom, Judge. You just swore him in. Now, such argument is disingenuous, says the judge, and it's made in bad faith, as defendants omitted what I said immediately after that sentence, which is, I'm here to hear him answer the questions. And he says, indeed, those are precisely the roles of the witness and the finder of fact. Well, yeah, Judge, but first of all, you caught yourself on the second half of that statement there. And the point is, you want him to answer questions the way you want him to answer them, okay? It is not the judge's role to rein in a witness. It is the government's role. And the judge kept screaming at Trump. And we went through the transcripts here, the excerpts that were posted, and we listened to them. And the government was even saying, hey, we're fine with Trump just rambling off. Let him go, because they're transcribing everything, and they're going to give it over to Jack Smith and to everybody else. They love it. He's under oath on the record. Let him go. And the judge was cutting him off. I don't want to listen to this guy. What, Judge? Mind your business. The government's okay with these questions. Talk to your clerk. Sheesh. So he is now saying, I'm not here to hear him. You go, what? Okay, well, obviously that's true. We know. You're here to convict him and to abuse him and the rest of everybody in his orbit. So he says, now I am precisely, that's what I'm supposed to do, is to hear him answer questions. Well, the government was okay with his responses and you weren't. So they say here, Engoron continues, and Trump also takes issue with my publishing of my high school alumni association areola newsletter, alleging that it was inappropriate to include links to articles referencing this case as it creates an appearance of impropriety. And of course it does. The judge was highlighting is like man from 1847 is in here. And then he would post, link, and all the links were bad for Trump. Judge orders this. Judge rejects Trump request. Judge orders summary. Blah. And he had a bonus torso photo in there that has, haunted a lot of people's nightmares on that email list. They're like, oh, just happening. What's going on? It's going to be a busy day at work today. Oh, I wonder what's going on at Wheatley High School. Oh, yeah. That's nice. I remember her, Barbara. She was very sweet. Oh, what's happening? Oh, my gosh. What are these? And then they run into the garage and dump bleach in their eyes. So he says, in 2007, this is Judge Engoron, I co-founded the Wheatley School Alumni Association, which we unfortunately read through, and began publishing the association newsletter. All issues are free of charge and reach approximately 4,700 email addresses containing no advertising. So boom, bonus torso photo, right in your face, almost 5,000 people. Now, they contain news about the school, its faculty, and primarily its graduates. When an online publication mentions a graduate, including myself, I include an excerpt or a link, or usually both. And consequently, I have been the subject of entries concerning this case due to its undeniable newsworthiness. Which you're gagging Trump over. You understand that? Of course it's newsworthy, so Trump should be able to talk about it. And you're not letting him. So in fact, Judge Engoron says, because of my job, I, the editor, have been subject of a fair amount of news coverage over approximately the past decade. However, I neither wrote nor contributed to any of the articles on which Trump focuses, and no reasonable reader could possibly think otherwise. No, but you are the editor of it, and you're including them all, and you're selecting the articles that seemingly have a particular bend to them. They're all in favor of you and not Trump. So you're not linking Breitbart, for example, Judge, are you? Saying that psycho judge is wrecking American democracy and ruining business in New York. Did you link to that one, Judge? No, you didn't. Many years ago, a legal ethics lecturer told a group of jurists, oh, this is great. Judge is giving us an anecdote here in a legal order. Great. Thanks for your anecdote, Judge. Are you going to footnote this at all? No. He says here, of course not, because everything's a red herring and he's not addressing anything. Honestly, I think he just types this probably when he takes a sleeping pill late at night. So many years ago, a legal ethics lecturer told a group of jurists, of which I was one, that, quote, judges do not lose their individual identities or personalities just because they are judges. Wow. It's brilliant. A significant part of my personality and identity, oh gosh, here we go. He's going to identify, is as a graduate of an institution. Well, that's, actually quite normal, that I admire. Okay, let's see where this goes. Who has taken, this could go a lot of different directions when we talk about identity. Who has taken on the time-consuming but gratifying task of keeping its alumni connected and informed about many topics, including his chest and his progress at the gym. Now, none of this has anything to do with, much less does it interfere with my presiding fairly, impartially, or professionally over the instant dispute, which I have now been doing for more than 3 years and which I intend to do until its conclusion. Well, no, Judge, it shows that you're biased, okay, by selecting articles that put you in a nice light. It shows you got a conflict of interest. Not only are you biased, but maybe you're getting some self-gratification out of this whole thing, okay, in many ways, more ways than one. To 5,000 people. Is there an unsubscribe button on that thing? Plaintiff has advocated for a full briefing schedule, emphasizing that although it believes Trump's motion is without merit, it believes briefing would economize the timing and the effects of any appeal. So even Tishy is like, hey, can we please respond to this? But the judge says, no, you can't. In good conscience, I cannot sign a proposed order to show cause that is utterly without merit, and upon which subsequent briefing would therefore be futile. So you're gagged from even, briefing. Sorry, Tish, you're not even briefing. The court has considered Trump's remaining arguments, including but not limited to Trump's assertions that the court's evidentiary rulings are per se evidence of bias, as they allege there are more rulings in favor of the government than of the defense, and they find them to be similarly without merit or dispositive. Now, I stand by each and every ruling, and they speak for themselves. And finally, the judge says, as I have made abundantly clear, the basis for overruling objections to allegedly time-barred evidence is legally sound, as there is a statute of limitations on claims, but not evidence. Accordingly, the court hereby declines to sign Trump's proposed order to show cause to get permission to move for a mistrial. Signed by the Areola judge himself, Arthur F. Engoron. And do you feel satisfied? Did he respond to any of Trump's points in there other than very topically, very, very briefly? We don't even have receipts for the donos. I'd like to see the receipts, Judge. Get your law clerk to show us the donos receipts that she made, because this is just about what you'd expect. So Trump, I'm sure, will be appealing these orders, and there will be a lot more to follow. Now, trial continued on in the day, and Engoron listened to more evidence from Donald Trump's defense. And to see what happened and what took place there, let's tune in and check out what Adam Klasfeld is reporting on. Of course, Adam Klasfeld reports over for The Messenger. A great follow if you're interested in this stuff. You can follow him at Klasfeld Reports on the X platform and elsewhere. And here's what he says. We got a new witness. who is on the stand in week 8, I believe, of trial. Now, the early part of testimony obviously involves your capabilities, your qualifications, your credentials. But here, Mr. Miller is back up on the stand. Now, he's got 2 decades, is this witness. 2 decades, Mr. Miller, of experience in insurance. Tishy tried to block him. His name is David, and he is Trump's witness. They say that he's got 2 decades of experience. He's the owner of an insurance agency called David Miller Insurance. And we got another big witness coming in later. Let me ask him some questions. Miller, I want to ask you about this internal report here. You recognize it? That looks familiar. It says here that this was about a decision to underwrite the Trump organization. You recognize it? Yeah. And this report says that Trump had a personal net worth of about $3.2 billion. Does that look right? He says, well, yeah, that's what it says. Where did this come from? He said, I don't know, underwriters, they often will rely on media reports. It's a pretty common thing. Journos are reporting on things, and so they'll look at those numbers. Is that common? Yeah, happens all the time. Now, no further questions. Thanks, Judge. Sometimes the media gets involved in valuations. Got it. Government comes up. This prosecutor is named Andrew Ammer. He begins cross-examination. He says, okay, David Miller. Now, you testified earlier that Zurich likely didn't inspect Trump's finances too closely. Didn't you remember you said that? He said, yeah. And you said that that might be a major deal, a favor to a major broker, somebody called Aon. Is that true? Yeah. Now, are you saying that the broker would have cut off business with the country's largest insurer? And Miller says, no, that wouldn't happen. Mr. Miller, are you being paid to be here today? He says, yeah, I'm an expert witness. I get paid money. How much? $350 an hour. Well, how much do you work? He says, I don't know, between 45 to 50 hours, before when I do an analysis on this. And so he's doing the math. Oh, so 350 times 50 hours, that's a lot of money, isn't it? Do the math at home for you math people. Now, Classfeld continues. Mr. Miller, I want to ask you about the Trump organization. Now, since the Trump organization was privately held, you'd agree that banks and insurers had no way to obtain documents that they did not get from public records? And he says, yeah, generally that's true. And you would agree with me that the state's position, that the Trump organization failed to disclose litigation or inquiries that could lead to a claim, right? So Trump had documents that were non-public, and he didn't disclose the litigation of those non-public documents to other people who might have wanted to know about that. Would you agree? And he says, yeah, I think I would. Yeah, a state's witness, an underwriter, he said it's standard fare to check for that. Would you agree with that? And Miller says, yeah, I'd agree with that. It's standard practice to check for that. All right, so we're still going through some valuation stuff, and kind of a short thread there, but Classfeld is reporting from the afternoon session, and we'll see what else we've got. It begins, we've got another witness up on the stand. And again, Classfeld's reporting, he's saying, Jeff McConney, now seated at the defense table, after lunch. The defense case is now going to be bringing in this guy, Jeff, to talk about the fraud evidence. And they call him up to the stand. Mr. McConney, you promise to tell the truth, tell the truth, how God? I do. Tell me about your background. Tell me about your experience. Well, he says, I began working on Trump's father's real estate business in Brooklyn, working with Papa Trump, Fred Trump in Brooklyn. Started working with him, worked my way up the ladder. And you did that for a long time? Yeah, a long time. Great family? Yeah, great company. So the Trump team, Jesus Suarez, who's up, the defense lawyer, he asks McConney, thank you, McConney. I want to ask you about the accountant for the Trump organization, Donald Bender. You know who that is? Oh, yeah, of course. Don, great guy. Actually, not a great guy. Yeah, Don, he's an idiot. We've been trying to blame him for the discrepancies. Oh, that guy? Yeah, moron. He says, Well, the accountants in these cases, they have carte blanche to anyone at Trump Organization. They can just go around and get information from anybody. He says, Bender? Oh, Don, that guy? Yeah, he could walk in and talk to anyone he wanted. It's not a structured company like IBM. He's like, I'd never work for an IBM. Like, we don't have like a CFO guy and all this, multiple layers. Fill out a form, get on the account. No. Don just walking around and asking people info. Trump's defense says, did anybody try to hide anything from Don Bender? Maybe try to hide litigation? No. He says no, that he didn't. And they take a break. Afternoon break. Judge says, 10-minute break, see you in 15 minutes. We're like, oh gosh, Judge, come up with a new joke. And we're back. McConney's back on the stand. He says, Trump's defense, Mr. McConney, I want to ask you about some different Trump properties. You're familiar with Trump Park Avenue? Yeah. And you're familiar with Lenox Hill? Yeah. And that's the one that used to be the historic Delmonico Hotel? He says, yeah. Did the Trump family live there? He says, yeah, Ivanka Trump once had a penthouse there. And they had options to buy a couple of units, and those units were well below market value, says AG, right? And McConney, he says, do you remember the spreadsheet that we talked about or you saw previously? Yeah. This one's related to the valuation of Trump Park Avenue. Is that true? He says, yeah. Now, walk me through how you came up with these numbers. He says, well, valuation is based on the anticipated selling price of unsold residential units and the selling price. And the judge finds that Trump Organization ignored the rent-stabilized units. Now, Trump's defense says, okay, Mr. McConney, I want to introduce an email to you from you, Jeff McConney, to Donald Bender, and one other person from March 12, 2021. Do you remember this, Mr. McConney? He says, yeah, I remember. It says in part, Trump Park Avenue, January 2020. You see that? Yeah. It says unregulated total was 179,219 on my filing, 17,000 for the regulated. Does that look right? Yeah, I recognize that. And so Mr. McConney, says Trump's lawyer, Jesus. Now the email, it seems to show that Bender knew about the above discrepancy between the rent stabilized units. Does that look right? He says, I see that. Is that what he calls an inconvenient fact? No, he calls it, that's kind of an inconvenient fact for the state, isn't it? He says, yeah. So in other words, Bender knew that there was a pretty big discrepancy. And he says, yeah, it's not convenient for them. Now, I want to also introduce a document about the valuation of rent-stabilized units for different properties, right? If they didn't do it this way in this property, let me show you how they did it in other properties. Government objects. Objection! Your Honor, this is totally irrelevant. Their objection's ridiculous. They argue about this. AG's counsel calls for the witnesses to leave the room. Your Honor, can we excuse the witness, please, while we get into this with you? Engoron says they should excuse the witness and argue. Yeah, let's get rid of him and then we can argue about this. The witness leaves the courtroom and Engoron says, yeah, I don't think it's really relevant, but I'm not sure. So I'm going to allow this into evidence, which is the other analysis, is the other valuation. It comes into evidence. And again, another day of valuation. So, all right. So that is Engoron's courtroom. We get a couple of additional witnesses. Of course, we also got Engoron denying Trump's motion for a mistrial, and Trump's defense, of course, will be appealing this and many more things. We'll be continuing to cover this and all of the other Trump trials, my friends. So thank you for subscribing. Thank you for checking out robertgovea.com. Now, if you want to get any of these PDFs, they'll be on robertgovea.com, along with a report that synthesizes this entire segment. You can sign up for our daily newsletter, get access to all this stuff. We don't want you to miss a thing, and we'll look forward to seeing you on the next one. All right. Now, we've got to change gears a little bit and talk about Fani's case, of course, sticking with the Trump trials. This will be a little bit of a shorter segment because not a long filing, but let's get into it. I think this is very important. Fani Willis is now plotting to schedule the Trump trial to be happening, to be in trial while people are voting in November. During the November 2024 elections, we're going to have weeks of trial before, we'll have trial during, and if Fani gets her way, we'll have trial after all people vote. And so we're going to talk about what's going on here because two things came out from Big Fani Willis. One, a motion. She submitted this in Fulton County asking for an August 5th trial date, which of course is several months before the November elections. And if the trial starts then in August, can we get it done before people go and vote in November? Well, no, because Fani says that this trial is going to last several months and carry us well into November of 2025. And so this came over from a sit down that Fani had with the Washington Post. Fani for DA. They posted this back on November 14th, so it's recent, saying that on election interference, Fani said, I think the case will be on appeals for years, which, by the way, is by design. They don't even care about this case winning it, in my opinion, right now. They care about dragging Trump down, putting an albatross around his neck, and then losing on appeal later when it doesn't matter. She says, but I believe in that case there will be a trial. I believe the trial will take many months. Many months from August? And I don't expect that we'll conclude until the winter or the very early part of 2025. Well after the election is over. Isn't that nice? Isn't that convenient? Here's what it sounds like coming out of Big Fani's mouth.
This is something that I'm hoping you are willing to talk about a little bit. When do you think this election interference case will come to a conclusion? And let me add a little bit of detail before you answer. You have said March in the past, and there are a couple of other cases out there that make that less feasible to my mind. I don't know anything, but that's just what it seems like. It can't be March. Can you give us any clue when this would wrap up?
I think a case will be on appeals for years.
Okay.
But I think that in terms of, I believe in that case there will be a trial. I believe the trial will take many months, and I don't expect that we will conclude until the winter or the very early part of 2025.
Okay. And that, I think, is by design, right? They want that to happen so that they can have months. Can you imagine? All of August, all of September, all of October, all of November. Trump trial, RICO case, election interference, the whole thing, right? And this is kind of nuts because we know that the DOJ, when we were getting really close to the 2020 election, they were saying we couldn't make any sudden moves against Joe Biden because there were whistleblowers who have now blown the whistle, but they were there working for the government at the time, saying that there were big problems. They were going to go investigate Hunty's storage units, and they were going to make a day of action and go move on him and go from overt to covert to overt. And they got stopped. Now, this is not the DOJ, okay? This is Fani. This is a state level case. So she doesn't have to comply with those same best practices. And so she can ask for a trial to start in August, just months before November starts, knowing that the trial is going to bleed into the election. And that, of course, is by design. So let's take a look at the motion. She also submitted this. She's asking for the trial to be held on August 5th, 2024 to start. Here's what it looks like. Filed November 17th, state of Georgia versus Trump and everybody else. Now, you'll notice this list is getting a little bit thinner. So some people have fallen off the list. Okay, Sidney Powell, Scott Hall's not on here. We also see Jenna Ellis is not on here, and Kenneth Chesebro. They all dropped off. So we got Giuliani, Eastman, Meadows, Clark are left. Misty Hayes we saw is left. And Prescott, Harrison Floyd, who has actually a bond hearing coming up, which we'll be covering soon. Now, this is what Fani is submitting. And let's see if she signed off on this one. She did. Blue ink, Fani Willis submitted this one into the court. Says, comes now, the state of Georgia, by and through Fulton County, Fani moves this court to schedule the trial for all of the remaining defendants for August 5th, 2024. That's pretty big. Now, the state requests that this, now we're going to see what the judge does, but the state requests this court schedule Trump and everybody else for a final plea hearing date, Friday, June 21st, and begin trial on Monday, August 5th. So if you don't take the plea soon, okay, you're going to trial. Like, pleas are going to be withdrawn and we'll go to trial. Now, a big part of me, my friends, some of this is speculation. I think we've got a lot of hints at this, though. I think Fani's bluffing. I do. I think she has a very weak case. She knows it. That's why everybody else got smoking plea deals. And I know some people still disagree with me on that these were not actual guilty plea convictions, right? They're not actually entered. They're just held in abeyance. The judgment of guilt has not even been entered. All of it has been set aside. I think Fani's cases are very weak, which is why she's panicked that the plea proffers came out and all the things. And I think that she might want this trial to not happen in August, by the way. Like, she may be okay if the judge, tactically, she wants it to start. But she also knows that she's, I think, got a weak case. And I think that if, like when she goes home and lays her head to bed at night, if the judge continued this case out, I think she might rest a little easy on it. Because after the election, then she can come up with some other justification for this. Okay, she can say that, and I think the same thing is going to happen with Alvin Bragg, that these cases can take the back seat to the J6 case, which is really, really what they want. So if they get a conviction in March, then they can sort of let up the gas on these other cases. Now, we'll see. Now, if something happened, they've got contingency plans is the point. Ideally, they get him convicted on all of them, but we'll see if that happens. Now, this proposed trial date, this is Fani writing, it balances potential delays from Trump and other criminal trials in sister sovereigns. So we've got Florida, which is scheduled for May, as we see. We've got DC, which is scheduled for March. So just think about this. So if March, let's say March, April, maybe this bleeds into May. So we got 2 months on that. So maybe 6 weeks. I think they said in Florida that this trial would be 2 weeks, which seems very low to me. Seems extremely minimal, like 2 weeks sounds short. So then you would have 3 criminal trials in 1 year, August 5th. And I still doubt that this trial goes, by the way. I think that the May trial probably gets bumped in Florida too, because of SEPA stuff. So that'll get bumped until after November. We'll see what the judge does on this one. If Judge McAfee schedules it for August, I mean, I think that's going to be incredible. But therefore, they say it's unlikely to be subject to delay. August 5th is perfect because the other trials will be going. Now, if Cannon moves hers, then Cannon may say, well, I can't move it to August, so I can't put it in September because that's too close to the election. And so maybe she bumps hers all the way into end of November, right? End of November, theoretically. Or even December. But she could just put it the week after elections, like literally the week after the election or something. By, saying, no, I'm not worried about the election, but that's the appropriate date and we'll get started there. And then probably postpone it again. So additionally, setting to trial on August 5th, says Fani, would begin trial within 1 year, which is the date of the indictment in a monster case with 19 co-defendants, and would show deference to each defendant and their constitutional speedy trial rights. The August 5th trial date would balance these two scheduling concerns. They say, in accordance with this court's standing order, the state also requests that a final plea date be scheduled on June 25th. The state will entertain negotiated plea deals up until the final plea date. After the final plea date, the defense will only have the option of non-negotiated pleas. And the state intends to recommend maximum sentences at any remaining sentencing hearings. Ooh. So that's going to be curious. So then non-negotiated means you can just go plead to the court. Like you can just plead guilty, but you're not getting a benefit from us. And when you go and plead to the court, in lieu of trial, we're asking for the max, which will be wild because the maximums, like the discrepancy between the maximum and what they got. So like, for example, okay, Kenneth Chesebro, Sidney Powell, Jenna Ellis, and Scott Hall, 0 jail time, not 1 day. And they all will have 0 criminal convictions, not a single one, if they can comply with the terms of the diversion deal. It's literally like driving school, okay? They all got driving school. Take the class, charges go away. And they all got charged with felonies. So if they would, so for example, if one person does not, take the plea and they get convicted, everyone else is going to have diversion and dismissal deals, and one person will go away for 20 years. And that's justice in Fani's court because she overcharged everybody, right? You see how that works, which is unethical. So here, moreover, they say the state requests this court to not consider any severance issues until the final plea date. In the current procedural posture, and she's trying to push people to take pleas, obviously, because she doesn't want this case to go to trial, the law favors keeping the remaining defendants together for trial. If we separate them, it would impair both the efficiency and the fairness of the criminal justice system to require, in all these cases of joint crimes where incriminating statements exist, it would be a lot for us to bring separate proceedings, present the same evidence again and again, require the victims to repeat the inconvenience and the trauma of testifying, and randomly favoring the last tried defendant who has the advantage of knowing the prosecution's case beforehand. So let us all go together. Now, the RICO conspiracy charge ensures that any trial would share the same evidence and witnesses. In fact, the case where the same witnesses, the same evidence and the same charges would be used against all the defendants. So we can do it all together. There's overlap enough. So judicial economy in the use of physical facilities and the time of the witnesses and the jurors and the court personnel and everybody involved, the trial court must consider these efficiencies against the possible conflicting interests of the joint or multiple defendants. So if they want to sever their cases out, they're saying no. Additionally, there have been guilty pleas from 4 defendants already, and more defendants could choose to enter guilty pleas in the future, and I think that they probably will. Waiting to rule until after the final plea date would place this court in an optimal position to adjudicate any severance claims, including, right? So they want them to be really, they want them to be very highly pressured into pleading before they can earn a possible advantage by severing the case. Don't let them sever it until we know what they're doing. Saying that it would confuse the law if we let them sever early, because then they can jockey who goes first and next, and then we got to present our evidence multiple times. So if they know they're going to trial, like for sure, and they're not taking a plea, then let them consider the severance. Finally, the state has experience and resources, Your Honor. We can try multiple defendants together. For example, we tried 12 people together simultaneously and effectively, in this case in Atlanta Public Schools. The Court of Appeals found that the trial court did not abuse its discretion when it denied a severance motion. Evans complained about the length of the trial, the number of the defendants, the evidentiary dispute with co-defendants. They said it does not rise to a denial of due process. So this Evans guy was probably just like one person. Well, I don't know what the story was there. Let's see. Additionally, the state still possesses the physical and technological equipment, including tables, chairs, and monitors from the APS trial, the Atlanta Public Schools trial, which are available for the upcoming trial. Like, we already got the camera set up. The state clearly retains the logistical and the prosecutorial capabilities to try all of the remaining defendants together. Trump and everybody together. Trial for the remaining defendants should be set for August 5th, as that date balances the potential delays from other pending criminal trials. And further, no severance motions. Don't let them try to get an advantage and sever their cases out until after the final plea hearing date. Once we know that they're rejecting our pleas and going to trial, then the court will be best ready to adjudicate the severance claims. And saying we should schedule this stuff now, Friday, June 21st for the final plea hearing date in 2024. Trial scheduled to start in August. And as Fani has already said, the trial should last for many, many months into 2025, which is exactly what they want. So if they can keep Trump bogged down in trial, if they can have every single news story every day talk about Trump being prosecuted, Trump charged with felonies, Trump RICO, Trump election law, they think it's going to help them win, I think. And then Americans are going to listen to this and believe that what they're doing is actual justice. I think that they have bitten off way more than they can chew. I think the polls are showing it too. And so that makes me nervous. What happens when you get people cornered? You know, sometimes they escalate things, and maybe they will. Maybe we'll see more from them. But as it stands right now, Fani and the plot is to create a trial that will cover and bleed into the election, so that when people are voting, when they're filling out their mail-in ballots, when they're showing up at the polls with their paper ballots, the news is telling us Trump is in trial, Trump is being prosecuted. We'll be here to continue to cover it, my friends. And thank you for inviting somebody to come over to our channel to check out what we're doing here. There's a lot going on in these cases that the media is just not covering, and we're trying to bring all of it to light, but it only really works if people can see it. So thanks for sharing it. Thanks for bringing people over here to join us when we go live at this time every day, and we'll look forward to seeing you on the next one. All right, my friends, now let's turn our attention over to Judge Chutkan's gag order, and you're going to hear more from the Court of Appeals now and a little bit less from me, which is always a good thing. And here is the segment because this is a fun one. Judge Chutkan's gag order coming under a little bit of fire in the Court of Appeals out of the D.C. Circuit. We're going to go through it today because the audio recordings are available. Isn't that curious? Chutkan and all of the other federal district courts, they really don't want us to hear much about Trump and his trial when it is on display in the 2024 election cycle. But they're talking about today the gag order because Chutkan has said that Donald Trump can't talk about the case. He posts stuff on Truth Social. It's very offensive to Jack Smith and those deranged thug prosecutors over there. They're constantly having their feelings hurt. Yeah, well, I can't believe what Trump posted on Truth, and sending each other text messages, crying to their spouses and so on. But this is the appeal. Trump says, I can say that stuff, okay? This is free speech in America, and if I've got criticisms against the DOJ, that's part of my free speech, first of all, and it's part of my political campaign, which is court-protected political speech protected under the First Amendment. So today, we're going to go through several excerpts, and some quite long, of the proceedings in the D.C. Circuit, because they are quite good. Now, I want to introduce you to the people and the parties who are joining us to debate this gag order, and ultimately, I want to make the point that I think that this is just a temporary pause. Very likely this is going up to the Supreme Court because this is the battle between two immovable forces. You've got the justice system, the sanctity of the criminal court, due process of law, and the court's authority to regulate itself versus free speech, political campaign. America's #1 candidate right now, according to polls across the country, who can't talk about his a political opponent who is using the Department of Justice, according to our interpretation, or you might disagree with that interpretation, but we should be free to make it weaponized DOJ that is going after his political opponents. Now, shouldn't we be able to say that? Here, we're going to be making that argument in front of these individuals. So let's introduce ourselves to the parties. This is the minute entry from the oral arguments on the way to the Supreme Court. This one's coming out of the United States Court of Appeals for the District of Columbia. You see the cases, United States of America versus Donald Trump. Trump is the appellant, the person who wants to appeal the gag order. And these are the minutes. Now, it says, proclamation being made, the court opened on Monday, November 20th at 9:33 a.m. The cause was heard as case number 1 of 1 and argued before the court by D. John Sauer, counsel for Donald Trump, Cecil W. VanDevender, counsel for the government and the DOJ. Signed off on by the clerk of the court, and you see the judges who are here are Judges Millett, Judges Pillard, and Judges Garcia, Judge Garcia, and that's who these people are. Judge Millett is an Obama appointee. We'll be hearing from her. And you can put names to faces. I think you'll be able to see who is who. We got Judge Millett. We've also got Judge Pillard. Sorry about that, Judge Pillard, typo, oops. We also got this one from Judge Garcia. Judge Garcia is a Biden appointee, and both of the other judges are Obama appointees. And you might say, oh, great, what's this going to sound like? And, you know, it wasn't as bad as you might expect because the First Amendment is kind of hard to dump all over because it's kind of, you know, the First Amendment. It's the first one, and it's pretty clear. But we're going to see how this all unfolds. Now, first up, as the party doing the appeal is Trump and Trump's defense in this case. It is D. John Sauer who's going to be arguing. We haven't heard from him in the lower level, but appeal lawyers, you know, appellate lawyers are different, are a different breed for sure. And so they brought him in to argue this. And this is what it sounds like. Now we're going to listen to 2 clips from him, and then we're going to turn it over to the government. Okay, we've got 2 more clips from the government. And so just for even time, I'm trying to keep the clips about even and also show both opening statements. And for context, by the way, if you want to watch the full link, the mind map and all of these stories are available at robertgovea.com. You can sign up, get access to the mind map, and listen to all these clips, read the documents there, robertgovea.com. But here, I wanted to just pause and say that the Court of Appeals, they're pretty aggressive at the appellate level. And the reason for that is because they got to tease through these issues. If we're on the way to the Supreme Court, they got to really unpack everything. And so when you hear these arguments, you're going to hear the judges are kind of attacking both sides. They're pretty aggressive with both sides. They're kind of in a position of ultimate skepticism. Oh, you say all this is true? Well, what if I change these variables? What if you're saying Trump has free speech, but does he have free speech about this, that, and this? And you, like strings on a guitar, you pull on the different variables and you whang, and you see if they, really reverberate. Because sometimes you might pull on a string in a case and it might not matter. Like, does Trump's free speech matter if it is election season or not? Or does he just have free speech? Because if it matters during the free speech, like if it's amplified during the election season, is it about the election or is it about the free speech? We want to disambiguate all the different things that are happening. And so let's jump in and listen to what happened when D. John Sauer, Trump's attorney, started out his argument in court in the D.C. Circuit Court of Appeals.
Thank you, Your Honor, and may it please the court. John Sauer appearing on behalf of the appellant, President Donald J. Trump. Gag order in this case installs a single federal district judge as a filter for core political speech between a leading presidential candidate and virtually every American voter in the United States at the very height of a presidential campaign. The order is unprecedented, and it sets a terrible precedent for future restrictions on core political speech. The Supreme Court said in Republican Party of Minnesota against White that we have, quote, never allowed the government to prohibit candidates from communicating relevant information to voters, and it's not the role of the government to dictate what topics are appropriate or necessary to discuss in the context of a political campaign. The gag order does both of those things. Cases involving gag orders imposed on criminal defendants or political candidates, the Brown and Ford decisions, have both given, in the words of Brown, the candidate, quote, absolute freedom, virtually unrestricted ability to comment on both the case in front of him and make a public statement that relates to his campaign as it relates to the case. So this is a radical departure from the only cases that have considered this particular form of restriction, a restriction on a criminal defendant who is also campaigning for public office. And it does so in the context of a hotly contested campaign for the highest office in the United States of America. In addition, the gag order, another unprecedented break with jurisprudence, relies completely on an insupportable heckler's veto theory. The gag order does not say, hey, your statements are going to, poison the jury pool by communicating directly with the members of the jury pool. What you have here is a rationale that says this speech, the speech that is targeted by the gag order, might, there's no evidence of this, but it might someday inspire some random third party to engage in some action that might result in harassment or threats to witnesses. This is a quintessential heckler's veto, which the Supreme Court has not traditionally subjected to scrutiny, even very strict scrutiny, but that is just categorically unconstitutional. And the reasons for that, if you look at the heckler's veto cases, in virtually every case, the argument justifying the heckler's veto is we have an absolutely compelling reason to do this, because the speech that we want to suppress is going to inspire rioting, violence, injury, death, whatever it is. And the Supreme Court has says again and again, you cannot do that. All the gag order cases relied on the government do not address this particular heckler's veto kind of rationale for criminalizing speech. And the Supreme Court has held us again and again that is not a permissible rationale to silence anyone. Those cases go back decades, and that government rationale goes back to at least the city of New York in the 1860s.
Would your position be any different if it were a year ago? If the timing were just a year ago, so we were much further removed from a political campaign? Would your position be the same or different?
Certainly a year ago, we would still be in the midst of a political campaign. I believe President Trump...
When are we not in a political campaign?
Right, okay. I don't mean to fight the hypothetical, but if you're saying that it was made at
a year ago, if it was a year ago,
right.
It was last November.
At a time when he was not a presidential candidate, all the other rationales.
But certainly still engaged in political speech.
Absolutely, core political speech.
So would your position be any different a year ago?
I think the gag order would still be unconstitutional.
Would your position be any different?
I don't see how it would be.
Okay, so the fact that we have a campaign going on does not matter. What matters to you, and this is still political speech, which gets very high protection, no doubt.
I wouldn't put it that way. I think that the fact that the campaign, and we have a whole series of...
Your position would be no different if it were a year ago.
Our position would be that it's still unconstitutional, but the campaign adds a additional and very powerful reason why it is unconstitutional.
But it's icing on the cake as far as you're concerned. Your position would be exactly the same without a political campaign.
I would say it's the crown jewel of a series of at least 7 fundamental
precepts. You need a crown jewel? I mean, you think the outcome...
No, you don't need a crown jewel. You just need free speech, right? He's correctly, I think, going back to the base layer of free speech, but when it is a campaign issue, it elevates that, because it's political speech is the core of what we're trying to protect here. It's redressing your government, right? Petitioning your government for a redress of grievances, because the current people in power have been corrupted. They are stopping the proper functioning of government. You have to be able to speak out about that. because you only have speech. They control the levers of power. And so I know the audio is a little bit fast here. This is they're just starting here, so everybody's all jacked up, talking really fast, but they're going to slow back down a little bit once the tension leaves the room. So this is more.
Outcome should be exactly the same, whether or not there's a political campaign underway.
Yes, I believe there are at least 7 independent First Amendment precepts that are violated by this gag order. Campaign speech is one of them. Heckler's veto is another one. So, for example, a year ago, we would still, if we had the same gag order, we would still be dealing with a categorically invalid Heckler's veto type theory. We would still be dealing with core political speech. Again, we would still be dealing with a situation where we have a restriction on criticism of public figures. That violates the whole public figure doctrine. There'd be a whole series of reasons it would still be unconstitutional. However, one of the most powerful and compelling of those, I'm sorry, Your Honor.
So, Mr. Sauer, you point to the fact that your client is in the midst of a campaign, but I trust you agree that a prior restraint is, no matter to whom it would apply, is subject to the highest level of constitutional scrutiny. That's your argument.
Absolutely. Yes.
So, and I also trust that you agree that your client is not above the law that applies to all other Americans.
He's subject to the First Amendment in principally, but yes.
He's subject to the law that applies to everyone. He's not above the law.
We certainly haven't argued that, Your Honor.
Right. And so the district court found that when the defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed. And we view that factual finding for clear error, right?
No, in a First Amendment case, I believe, as we cited in our standard review section under Houston against Hill, the court should engage in a plenary review of the record under de novo review. That is a mixed question of fact and law.
But for the findings about what happened in the world, we look at that for clear error, and then we look at the First Amendment implications de novo.
Looking at that particular.
Okay, so they start getting into some technical stuff. They're basically asking, what are we trying to do here? What kind of standard are we applying to this matter in front of our court right now? Like, what are we talking about here? Because you got to be very careful about that, right? We don't want to spiral off. Like, it sounds like we're spiraling off into a bunch of other hypotheticals and stuff. Well, what if Trump wasn't running last year? Or what if this case was a year ago? And all, like, it's going into hypotheticals. But again, she brought it right back down to, well, what are we doing here? Okay, we've got an order. It's a written document from Judge Chutkan, which came back from the lower level district court. And the order says a bunch of stuff. And so specifically, like, we got to go through this order. And what are you arguing about? Are you arguing this paragraph? Is that good or is that bad? Is that legal, unconstitutional, limitation on free speech or not? Bit by bit. But also the question is, what rule and what rules and standards do we use to measure the lower level case? And so they start going back to that. Are we de novo on this? Are we, abuse of discretion? These are the different appellate standards. And so a lot of that is quite technical and boring. And so we'll fast forward through it. Now, one of the biggest issues, and really what I want to spend most of this time talking about, is causation, right? And this heckler's veto concept. The heckler's veto is this idea, somebody's up there speaking, they say something, the person who heard the thing doesn't like them, or they do something that is bad, and the person who said the thing is responsible for that person doing the thing or causing some problem. And that means that if you say anything to somebody in any context and they do something and they point the finger at you, you're responsible for that? Even though you have free speech in America and you're allowed to say things. Now, again, if you say something illegal, like if you're threatening or you're inciting somebody to violence, there's already laws against that. You already can't harass people. You already can't threaten people. You already can't incite a crowd, right? All these types of things. So it's already illegal. But what they're trying to do is gag Trump from talking about stuff that is otherwise protected. And the question is, they're saying there's harm from Trump's speech. We talk about following the bouncing ball on, the kids shows. Dun, 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 dun. Same thing here. If Trump says something or posts something on social media about deranged thugs Jack Smith, or about Molly Gaston, the highlighter queen, or about Jay Bratt, whatever his story is, and other things, can they do that? And if Trump says that, does the bouncing ball fall into harm such that the causation exists that Trump can be gagged in violation of his First Amendment rights and our First Amendment rights? And I never want to forget that. We have a right to hear from him about this. Trump is the subject of this. There is no person in America who is better qualified to talk to us, prospective voters, about the corruption and the disgusting behavior from the deranged thugs at the DOJ's Jack Smith office. He can see it firsthand. He's there experiencing it every day. We want to hear from him. And they're saying we can't. That's a violation of our rights. So this is John Sauer, again, back up in the Court of Appeals, having oral arguments with the judges. And here's what it sounds like, talking about causation. How can we blame Trump for certain things?
Every voter in the United States of America.
I do want to get to questions about the scope of what he's able to say, but just briefly back to the evidence. You're certainly correct that most of the threats at issue, this pattern of statements followed by threats, is from 2020. But I think the link might be, and I wonder what your response is, that that was all about the same subject matter of this case. So essentially what the district court is finding is we have a past pattern. When the defendant speaks on this subject, threats follow. And now he's making similar statements again. We're months out from the trial. This is predictably going to intensify as well as the threats. And so why isn't the district court justified in taking a proactive measure, not waiting for more and more threats to actually occur and stepping in to protect the integrity of the trial?
There's an evidentiary burden here. The evidence, actually, it isn't just that there's no evidence now, it's that the evidence we have now completely counteracts that inference, because it is undisputed that President Trump has been posting about this case almost incessantly since the day it was filed, and they haven't come forward with a single threat that's even arguably inspired by any of his social media posts. The only threat they talk about in their brief is from the Schrei decision, from the Schrei case from the Southern District of Texas. I strongly invite the court.
Well, counsel, and a death threat to the district court judge in this case.
Right, Abigail Jo Schrei, that is the August 5th telephone call. If you poll, it's Southern District of Texas.
The day after he said, if you come after me, I'm coming after you, that threat issued.
I strongly encourage the court to pull both the probable cause statement and the detention order from that case, where there's evidence that that particular threatener, there's no evidence of any reading of social media. That particular threatener is a unemployed, mentally unstable, heavy alcoholic who sits on her couch drinking beer all day, according to her father, never leaves the apartment, watches the news, not reads things on social media, watches the news on TV, gets angry about it, and makes angry, threatening calls.
So I'm sorry, counsel, this might have been partly my...
So that's the threat, right, that they're citing. He says, look, go read the probable cause statement, okay? Those are the documents, the charging documents. This is why we think there's enough here to charge this person with a crime. That person was already charged with a crime. Now, the phone call happened simultaneously to Trump, but they tried to pin it on him. She's just an alcoholic who sits at home, is just angry at people, doesn't even watch social media, watches the news.
But I want to go back. Imagine all we had was the 2020 pattern. That evidence is very specific. It's about when the president speaks on this issue, events around January 6th, and that there are very specific threats that people receive. And again, that was a time where, as you're saying, the atmosphere was very tense. As this trial approaches, the atmosphere is going to be increasingly tense. Why does the district court have to wait and see and wait for the threats to come, rather than taking a reasonable action in advance?
Again, the standard is imminently impending, solidity of evidence. We have an inference from stuff that happened 3 years ago, countervailed, contradicted by the evidence we actually have here, which is wall to wall. I mean, they are saying, oh, it's an imminent threat that someone could be harassed.
Let me ask you, Mr. Sauer, the conditions of release in this case prohibit your client from communicating about the facts of the case with any individual known to the defendant to be a witness, except through counsel or in the presence of counsel. Your client signed those conditions of release. Counsel before the district court was quite clear that that was not being challenged. How, under your analysis, would those conditions of release not be invalid? Are you taking a position that those conditions of release violate the First Amendment?
No, we have never challenged the conditions of release, and the president has complied with them.
And how under your analysis would they not be unconstitutional?
Well, a violation of that condition of release may be the response to Judge Millett's question from earlier.
I was wondering about
whether that would be something, for example, that might not be criminal, but would be a clear and present danger to the administration of justice.
I don't want mites. I'm really trying to understand your legal test. If he were to pick up the phone and call someone that is known to him,
good questions,
to be a witness, prospective witness in this case, and speak with that person without counsel present, would that would violate the restriction undoubtedly? Would the First Amendment protect that communication under your test?
We have not contended that.
It's not what I am asking. I'm asking you to apply the test that you propose us, because we have to write a test that can be applied. Right. And we have to know how it's going to be applied. So I'm asking your position, your legal position. Would that phone call be protected by the First Amendment or not?
Is it a phone call where what's that is Happy Thanksgiving, or is it a phone call where
I'm not telling you why, because the order, the release restriction doesn't care about the content. So he picks up the phone and calls a witness in direct violation of the terms of release.
We do not contend that would be protected by the First Amendment.
Okay, so that would not violate the First Amendment. That is allowed under the First Amendment.
Yes, that's completely consistent with the positions we've taken in this case.
And now if the next hypothetical is he gets on the phone and he says, X, Ms. X, you've always been someone, courage, backbone, a loyalist, a patriot. And loyalists and patriots don't talk to prosecutors in my case, and hangs up. Okay, if he said that,
I think that would be a clear violation of the terms of
Yes.
release.
Okay.
Also
What if
unprotected
he
by the First
instead
Amendment.
gets on a stage somewhere or on social media and says that exact same thing? Ms. X, a public figure, is being bothered by the prosecutor. But people who are loyal, honest patriots don't talk to the government.
He hasn't said that, and it is a
Please answer
mischaracterization.
the question. I'm not suggesting he has said that. This is to be clear for the record, this is a hypothetical question. Does punishing that conduct, because he's not speaking directly to the witness, he's doing this on social media or at a town hall.
So the judge is pulling on the guitar strings right now, just to see what resonates.
Or a news interview. He says that. Does it violate the First Amendment to say that's prohibited?
If he's communicating with the American electorate about matters.
I
of
told
utmost
you the
consequence,
facts. Okay, so your answer is no.
I got to know more about the context of this
Oh,
statement.
I've given you all the context you need to know. If
Well-
he does it over the phone to the prospective witness, you've said First Amendment prohibits it. If he says it with a megaphone, knowing that witness is in the audience,
Then you're very likely in the same scenario.
okay?
But again,
And if he does
again,
it on social media, knowing that person's a social media follower of his,
Again, I think you're getting further afield and more into core political
But
speech.
doesn't
at
that
this stage.
have to be your answer? I mean,
Which?
Legion are the cases that you have to agree, as you did with Judge Millett. Legion are the cases that say there's no right of a criminal defendant to try his case in the media. That's what the court is for. And of course, what's difficult about this case is that there is some substantive overlap between what the defendant wants to do in campaigning and what the prosecution here is doing in the case. But to the extent that there's an ability to distinguish between trying this case in the media and running for president, clearly he has no entitlement to do publicly what is well established he could not do one-on-one.
Well, he doesn't have the right to try the case in public, but he has the right to speak in public about his First Amendment concerns, right? Utilizing the First Amendment about his concerns about the DOJ.
To that witness.
I would say two things in response to that. One is that there's not some overlap, there's near complete overlap between the issues in the case and the issues in the political campaign.
True.
Secondly,
That's why you don't
the statements in the case that says you can't try your case in the media are all about cases that involve influence on the jury pool. And we don't have that rationale in this case because the district court expressly rejected that.
I appreciate that, but what about, you said that there's a complete overlap, but what about the portions of the order that cover let's say the court's administrative staff?
Yeah,
There would be no
Judge Engoron
reason
problem.
to campaign on any of that.
Yes,
That was
there
drawn,
is.
there was no evidence presented on that issue at all. He's never made a statement about court staff here.
So
That
that's
was
your
drawn from the
concern?
New York situation that we briefed,
That's-
where it was core political speech. That illustrates the hazards here. There was no evidence on that particular case before the district judge. Apparently, it was relying on, sua sponte reviewing of media reports, when in fact, the statements about the principal law clerk in the pending New York civil trial were absolutely core political speech. They definitely violated the First Amendment.
Yep.
I'm talking about in this case.
Yeah, so this is interesting because we've covered the Engoron case ad nauseum here, and it is the judge he's making the same point that we just made in the prior segment, that the Trump defense is responding not to Tishy's arguments, but is responding to the judge's arguments, right? On their own, the court just brought it up. And that what's happening is that the clerk of the court staff, Judge Engoron's GF, the judge's Greenfield, is involved in the trial in a way that warrants comment on it, right? They want to comment on it. They are able to comment on the institution of the judiciary, not just the individual people, but the whole structure. It's all protected.
Where there's an effort prophylactically to protect court staff. And my premise is, or my question for you, is when you say there's complete overlap, it seems that that's an easy case where there actually isn't overlap.
It's not easy. It's
Individuals who
happening
are
in New
working
York.
for the judge assigned to this case would be no topic in a campaign other than an effort to undermine this case qua case.
I mean, I think I would say a couple of things. I think we're talking hypothetically.
Yeah,
The
we
president has
are.
never made a statement relating to this case about any court staffer that I'm aware of.
But the
that's
order,
ever-
as you well know, and as you've challenged, the order applies to court staff.
with no evidence to support it. That
I
can't satisfy
appreciate
any.
that aspect of it.
Yeah.
I appreciate that aspect of it, that you've made a point about whether there's evidence or not. But I'm talking about the claimed overlap between political speech and the speech that's restricted by the order. And I'm positing that there actually is speech restricted by the order that would not be campaign speech but for this case. And surely you can see that.
I think the New York decision shows exactly the
but
opposite.
this-
The
we're
point
not
the
talking
court
about
staffer
those
was-
circumstances. If there were a staffer of the judge about whom it became clear that there was some political bias. Nobody disputes that the defendant's team could and would file a motion with the judge to raise a concern about that and comment on how the judge ruled on that. But that's not where we are. We're in a situation of prophylaxis, and that's really what I'm asking you about. A prophylactic situation where
The judge literally ordered them in New York not to file motions before relenting.
nobody who works for the court, these are career people, nobody volunteered for this assignment, none of them have life tenure, they're just trying to do their jobs. Nothing about them would be campaign speech in the absence of a case.
Are you kidding? The law clerk donated thousands of dollars to Democrats, was running for office, was seen at rallies with Chuck Schumer, was dancing around in the streets with a bunch of Democrats. All of that is relevant and is free speech when you're talking about a political prosecution, which is what Trump is alleging. Now, you might disagree with that, but it's the First Amendment and his right to make that argument to the American people. And I happen to agree with him.
What we see in New York is that if you enter that
This is not
prophylaxis
New
now
York.
based on
We're not in New York.
If you enter that prophylaxis now based on zero evidence, no evidence at all, no evidence of the political bias might be as of the court staffers, and no evidence of any statement about any court staffers. And if it later turns out that there's an extremely biased court staffer, we have a huge First Amendment problem. We have a prior restraint based on no evidence, which is what this is.
Let me ask you that.
Prior restraint based on no evidence. No evidence. And so that is John Sauer going in and delivering the oral arguments in front of the 3 Democrat appointed judges. And so he did a good job, right? I mean, he's in kind of the lion's dens there, and they talk a lot about causation, which I can certainly appreciate. But let's turn our attention over to Cecil VanDevender, because we got some good exchanges here. And as tough as the judges were on Trump, they were also bringing it to the government pretty aggressively. Now, this first segment's talking about whether there are direct threats, right? And this is the following the bouncing ball. Trump posts something, Jack Smith's a deranged thug, somebody gets murdered. How do we connect the 2 dots? Well, let's see what the judges say about this. This is the government presenting their case, and the Court of Appeals for the DC Circuit responds.
Thank you, Your Honor. May it please the court, Cecil VanDevender on behalf of the United States. The district court correctly found that the defendant's well-established practice of using his public platform to target accused adversaries, including trial participants in this case, poses a significant and immediate risk to the fairness and integrity of these proceedings. The order the district court crafted to address those risks should be affirmed for 3 principal reasons. First, the unique factual record before the district court. Second, the unusual narrowness of the resulting order. And third, the recent evidence demonstrating that the defendant is fully capable of understanding and applying with the order while it's in effect.
I just want to follow up. You just said significant and immediate risk. So are you not embracing the Gentile test?
No, Your Honor, to be clear, the Gentile test is the constitutional test that applies. Significant and immediate risk is the language that the district court found, so it sort of assumed that the
Those are kind of different words.
Pardon?
Within the law, those are substantial likelihood of material prejudice and significant and immediate risk, I think, are 2 different legal tests.
So she's saying you've got this one case that has this test. Chutkan used some different words. Why did she use different words if the law says these words? Why is the difference?
Completely agree, Your Honor, and the Gentile test of substantial likelihood of material prejudice is the correct legal test, but because the district court incorporated the higher test of the defendant proffer, that is the significant and immediate risk test, I think that does inform the scope of the order and informs the findings that the district court made, but to be clear, the Gentile test is the one that applies.
Mr. VanDevender, where is the finding that you're relying on?
It's on page 2 of the order, Your Honor.
So now we're talking about the types of harm, right? Substantial, imminent, likely, all these things. If Trump says something and we follow the bouncing ball, how do we connect Trump's statements to the potential harm that we want to limit? Well, it has to have a substantial likelihood, whatever. Where's your authority for that?
The follow-on order? The order?
Yes, this is at Joint Appendix page number 230.
Yeah. The court finds
Yes,
that such statements pose a significant and immediate risk,
exactly.
that witnesses will be intimidated or otherwise unduly influenced by the prospect of being themselves targeted, harassed, or threats, and 2, attorneys, public servants, and other court staff will themselves become targets for threats and harassment. On the second part, number 2, applying to staffs of the special counsel and of the court, the nexus between the concern that they be targets for threats and harassment and the administration of justice is not entirely apparent from the district court's order. Can you help explain that? I mean, for example, the district judge is not no speech relating to the district judge is gag.
That's correct.
And that's in part because we trust that the district judge will not be swayed by anything that the defendant says. How then could the district judge's staff affect the administration of justice?
The district judge's staff?
Yeah, any effect on them of non-criminal harassment and threats?
Well, I think exposing trial participants, whether those are courtroom staff, line prosecutors, or others, to the risk of threats, harassment, and intimidation poses a systemic risk to the fairness and integrity of the proceedings.
How so?
It creates a world in which people who are public servants will have to decide, do I want to handle this type of case? Do I want to press on with the sort of prosecution that we think the facts and the law demand? Or in doing so, will I run the risk that I will be threatened, my family will be threatened, there's a chilling effect on the whole.
Again, if your family's threatened and all those things, those are crimes, right?
Pass over the whole.
Like the law already provides major disincentives to people to do that, is my point. I'm not saying that somebody should like be the victim and then say, well, now I get to decide whether I want to continue to work for the government or not. And then now that this is going, I'm saying the law already protects against that. Like we don't need another law to gag Trump when we already have laws that disincentivize people from calling and threatening court clerks, which I totally, and I seriously like cannot make this warning enough. Text messages, phone calls, emails, anything that is even like remotely mean to an elected official, they go bananas over that, right? They absolutely go bananas. Like, oh, you're threatening my dog. You're like, no, I didn't. I just said you're doing a bad job. They're like, well, you're going to jail now. So, when Joe Biden's out there saying, text me your thoughts on my administration, it makes me very, very nervous because of that. Like we protect our public officials and court clerks. Like if you bump into a prosecutor, they're like, class 5 felony interfering with a government official. You're like, jeez Louise. Meanwhile, you can like stab and eliminate defense attorneys and they're like, well, whatever. There's, they're like, a dime a dozen. Like they pass laws to protect themselves at higher levels than other people. The law already provides these protections. You don't need to gag Trump to do it.
If the trial participants feel like they're at risk just as a result of their participation in the case. Separately.
And that's, the way you worded that, it made it sound like before they became part of the team, like in the future, other staffs might hesitate before joining the team. Is your submission also that existing staff might quit?
Well, I think there's certainly a risk of that. And certainly the court doesn't have to ask each staff member, how likely are you to quit if your family receives a death threat? I don't think there's any basis to say that in the absence of the likelihood that you will actually be deterred from doing your job, you have to tolerate threats and harassment being directed towards trial participants.
I had just a sort of very specific question. You mentioned the families, and the district court from the bench said that the gag order applied to the families of the staff of the court and the prosecution and the defense counsel, but the written order doesn't reference that provision. But what is the government's position as to whether the order currently applies to family members?
Our position is that it does, Your Honor, for two reasons. First, the beginning of the order, of course, incorporates the oral explanation. Okay. And as the court said orally, the prohibition on targeting family members, in her words, goes without saying. And so I think in district court's view, because the prohibition extends to these specific categories of trial participants, it necessarily extends to their family members as well.
So as I take it, your position is less a substantive one, that it would affect their impartiality, but is more a question of whether the people would even be willing and able to do the work.
It's partially that it would threaten whether they're willing and able to do the work. It could also threaten the way that they are perceived by the jury. I know that my friend on the other side has suggested that the district court disavowed any sort of jury taint as a rationale for this order, but I disagree with that. What the district court did disavow was the request by the government to include within the scope of the order post-targeting the jury pool in the District of Columbia, said that can be dealt with through voir dire. I'm not going to prohibit those statements, but I think the district court very much incorporated the idea of trying the case in the media, polluting the jury pool, prejudicing the jury. If the jury is presented, if the case is presented to the jury by people about whom there's been a months-long persistent drumbeat about their corruption, inflammatory comments about them in the public, that could affect how the jury perceives them.
Wow, pretty amazing, right? It could impact how the jury perceives the prosecutors if they show up and there's this onslaught, right? There's this consistent drumbeat of Jack Smith's a deranged thug. Jack Smith's a deranged thug. Molly's the highlighter queen of the DOJ. Jay Bratt, is, we'll leave that one. We've got a lot of other things, right, that we continually hear from Trump and a bunch of people on the right calling him all sorts of bad names. And that's going to cause justice to be improperly administered. Well, isn't that curious that the other side can do this? Do you think that there is just the other side saying nice things about Trump? Trump's a pretty decent guy all day, right? No, everywhere you turn, every single person in the media, mainstream media, all of the DOJ's friends out there at the Washington Post, the New York Times, all of the political candidates running against Trump, people like Chris Christie, all these guys showing up. Trump's got 91 felonies. Trump's got 4 different indictments. Everywhere you turn, right? It's the same broken record time and time again. Do you think, Mr. DOJ prosecutor, that the jury's going to show up and just be tabula rasa there, blank slate, after they've heard that for the last 3 years, that Trump is an insurrectionist? But no, he's more concerned about Jack Smith's reputation being damaged because Trump, who has a fraction of the megaphone that the rest of the media has, is hurting Jack Smith's credibility. Give me a break. And so now we've got a long exchange here, but quite a good one, where they really are kind of addressing this causation issue. And I want to spend some time on this because this, again, is the government prosecutor and the Court of Appeals for the DC Circuit.
How do we know what he gets held accountable for? I mean, this is the internet era. He's a high-profile public figure who posts. It's lots and lots and lots of followers. But it's also covered on news channels that have listeners, and newspapers that have readers, and all manner of media can communicate his words to people of the public. How does a district court reasonably decide which postings he is responsible for prompting adverse conduct, resulting in adverse conduct, and which are he's protesting, he's expressing his views as the First Amendment allows, and in a social media world cannot be held responsible for what everyone anywhere in the United States does when they hear about it?
Two answers to that, Your Honor. I think first is the sheer number of occurrences. So certainly if there had been one time when he posted something derogatory about a person and then at some point thereafter that person was a recipient of a threat, I don't think we would be here. The sheer number combined with the testimony of the people who experienced it on the receiving end, who said what changed when the defendant tweeted about me was I started getting much more graphic, much more specific, much more pervasive threats. When, as one of the witnesses, a poll worker in Georgia testified to Congress.
Do you have any of that with respect to his statements about this criminal trial?
No, none of the people who have been directly threatened as a result of this criminal trial have testified about that exact phenomenon, although again, I think the context around the threat to the district court is worth emphasizing. So the indictment came down on August 1st. The arraignment was on August 3rd. Before traveling to the arraignment, he issued a public statement saying, unfair venue, unfair judge.
Okay.
The next day he posted, if you go after me, I'm coming after you. And the day after that, the district court received the death threat. So yes, it's a matter of inference, circumstantial evidence, of course, but the district court made those findings. And to Judge Pillard's point earlier, those are findings of historical fact that should be reviewed for clear error.
Okay, so he is saying that the phone call that we heard about from the last clip where Trump's defense attorney was saying that was an alcoholic who was sitting on her couch, who watches the news, who doesn't even listen to social media. She just made a phone call in a drunken stupor to the judge and said some things, and she's already being prosecuted. In fact, there was a probable cause statement and they've gone after her. Dad says she just sits there on the couch all day and makes phone calls. But he says, yeah, but Judge Chutkan blamed Trump for that. And you see what they did? These sneaky prosecutors, very dishonest, is they tied it timeliness to the time, to the calendar dates. Indictment came, arraignment came, Trump made a statement, and they just scoured, okay? They were going through Judge Chutkan's text messages, her emails, her phone calls, and they're like, did you get anything? Did somebody cut you off on the way home, Judge Chutkan? Was somebody mean to you at the grocery store? Did they steal your parking lot? Oh, okay, so that's an attack on you. We're going to blame Trump for that, and they did, essentially. And so he is reiterating that. He says, Your Honors, Court of Appeals, I can't debate that, really. Judge Chutkan put that in her findings of fact, even though it's not a real legitimate threat caused by Trump. No causation there.
And because I know you referred us to the district court on page AA85. Special counsel has been subject to multiple threats. That's one thing. But the special counsel's office has been targeted through inflammatory public posts. I guess intimidating communications and then inflammatory public posts. But doesn't the First Amendment protect? And this is, to be clear, these comments have come in the course of a presidential campaign, or I guess at this point, a party nomination campaign.
Yeah, for president.
Inflammatory language?
So, Your Honor, our position...
Surely there has, I asked them about balance for protecting the criminal process, but I guess I'm asking your position, which doesn't seem to give much balance at all to the First Amendment's vigorous protection of political speech. And the notion that high-profile public figures or governmental officials who've taken on enormous responsibility like prosecutors can't stand up to some inflammatory language seems to me to contradict Supreme Court precedent, and seems to me sort of a very troubling lack of balance on the free speech side on the part of the prosecution in this case.
Oh, yeah, she's right. It seems interesting that these government prosecutors can't stand up to some inflammatory language. They can't get it together. Oh, they called me a highlighter girl. Oh, no, because I'm a deranged thug. Oh, no, I'm so pained by this. I can't handle it. Here, one more time.
And the notion that high-profile public figures or governmental officials who've taken on enormous responsibility like prosecutors can't stand up to some inflammatory language seems to me to contradict Supreme Court precedent, and seems to me sort of a very troubling lack of balance on the free speech side on the part of the prosecution in this case.
Our position, Your Honor, is not that these statements in a vacuum are unprotected. It's that Gentile presupposes that the restricted language is protected, as Justice Kennedy said there. That was classic political speech directed towards the government. Nevertheless, it can be proscribed if there's a substantial likelihood of material prejudice to the proceedings.
And how do inflammatory posts about the special prosecutor create a substantial threat of material prejudice to the proceedings?
So that's what I think we tied back to the record, which is that there's a pattern, there's a dynamic. It's very clear that when the defendant engaged in repeated inflammatory personal attacks on someone, there's a causal link between that person then receiving harassment, threats, and intimidation. And as I was...
Well, if there's actual threats, then that's a crime, and that can be dealt with.
What's the causal link?
But
If it's short of that, if it's, again, we had the Fifth and Sixth Circuit cases, and if you've got someone who says that prosecutor's out to get me, that I think there was allegations that the prosecutor's racist in one of the cases, this is all a political vendetta. Are those things allowed? They're pretty inflammatory.
Well,
When someone a racist is pretty inflammatory.
Yes, Your Honor. The district court tried to craft a very narrow order that allows some ample room to criticize the prosecution as political.
How does it do that if you say you can't target the special counsel?
Well, the district court, I think, draws a very clear distinction between attacking institutions and processes on the one hand and attacking individual trial participants on the other. So saying that the prosecution is politically motivated.
The prosecution is an governmental institution, right? It's not a personal job. It is the government, right? When the prosecution speaks, even when it's an independent counsel, they speak for the United States government. So I'm not sure that line works so well.
No, that's absolutely right. Maybe I was unclear. What I'm saying is attacks on the prosecution, calling it unfair, calling it politically motivated, those are all fair game.
But you can't say the prosecutor is politically motivated.
That, I think, well...
That would certainly count as targeting the prosecutor.
I think the special counsel himself is a somewhat unique case because he is both an individual trial participant and very much represents the institutional interests of the Department of Justice. So for him, we would concede that merely kind of referencing him or criticizing him...
The prosecutor's working with him and under his supervision.
Highlighter girl.
You can't say they're politically motivated?
If you're talking about individual line prosecutors, particularly if you're mentioning them by name, then know that the mechanism for that, as Judge Pillard alluded to, is file a motion. Certainly if you think that there's some political bias.
Just to file a motion every single time he wants to say all the prosecutors in the office are politically biased against me?
To be clear,
I mean, it might not be true, factually, might be, who knows, but I'm not suggesting that it is, it's just a question. But if in his mind, in his view, all the prosecutors in the office are politically biased against me, he has to file a motion before he can say that? That's not much, taking much account of the First Amendment interests at stake.
Well, I think if it's at such a high level of generality, everyone...
How can you tell that from this order? That's definitely targeting folks in the special counsel's office. So it's definitely prohibited. So I think that's why you're saying he has to go file a motion to make sure he's allowed to say that.
Well, the motion I'm alluding to, Your Honor, is not a motion to ask for permission to speak about it. What I'm talking about is avoiding a two-track process here, where there are claims that get presented in court and then a whole separate effort to kind of malign the people involved, suggest that there's some improper purpose or motivation or bias that's never even raised with the court.
That is literally what they're doing against Trump every day, okay? Liz Cheney had 8 hearings on it.
I mean, the defendant's free, of course, course, if he thinks that there's a colorable claim of prosecutorial misconduct or prejudice, likewise judicial, to file a motion seeking disqualification, dismissal, and then he can talk about the fact that those findings or filings exist. But what he can't do is say, I'm going to have this turning narrative that there is a political bias, but I've never presented it to the court.
But, so imagine, I understand he hasn't participated in debates thus far, but if he were to choose to participate in a debate, and the other folks who are competing for the Republican nomination, let's just say they spend a lot of time talking about, you know, you're an indicted felon, you're being prosecuted by the United States government, they'll prognosticate, you're gonna, you could be found to be a criminal before the election, and they have all this evidence against you, the millions of pages that they talk about in the record here. And so they're going on and on and on during the debate about this criminal prosecution. And you're telling me he can't say,
nope. Not unless he checks with
public
Jack
record
Smith.
prosecutors paid by the taxpayers, your names are public record. A, B, and C prosecutors. It's all a political vendetta. They all are doing the bidding of Joe Biden. Again, I'm not saying anything's true here. I'm just saying that's not the test of free speech in this country, thankfully.
It is true, Judge. It is true.
He can't stand on the stage and say that.
So, Your Honor, he can certainly say this is a politically motivated prosecution brought by my political opponent. The Department of Justice is corrupt. I will be vindicated at trial, all of that stuff. But when he starts naming
he has to speak mismanners while everyone else is throwing targets at him.
Yes, Judge.
Well, and it can't be that he can't mention Mr.
He has to speak mismanners. He has to say, well, they're, everybody, the DOJ as an institution's corrupt, but the people who are prosecuting me, I really can't comment on because the government has their fifis hurt. Come on. Judge is on the money with this one.
Who, I mean, for most people in the United States, given the number of legal battles in which this defendant is embroiled, the easiest way people have of referring to this case as opposed to the others is Jack Smith. Surely he has a thick enough skin. He's on this team. The two interests that you mentioned, which are one, the person would be dissuaded. I have little doubt that he will not be dissuaded. And then the other, that his impartiality or integrity would be impugned in the face of the jury. First of all, I'm not sure I see the district court having made any such determination or even followed that reasoning. Am I missing something supportive of that link?
Well, I think it's very clear that the district court is, because the whole rationale is premised on ensuring the integrity of the proceedings and the fairness of the trial. Of course, the court wants to make sure that the jury is not presented with extraneous information that would not be admissible in court that could prejudice their determinations. And I think part and parcel of that is how they view the trial participants. But
the jury needs to be protected from extraneous information. So Trump cannot speak, but is there any gag order for the media? Like, should they be blacking out the media in Washington, D.C. for the prospective jury pool? Because they don't want them to be biased, right? In other words, the same things, they would obviously deny that. They'd say, we fixed that in voir dire, because they do. Did you hear anything about this case? Yeah, I've been following it all day. Okay, do you have any opinions on this matter? Can you be fair and impartial? No, I can't. That Trump is guilty. Okay, well, you're not going to be a good juror. Or, I heard a little bit about it. Can you set that all aside and be fair and impartial? Yes, I can. Sure, yeah, I'm a good Democrat. I'm happy to play this stupid game here in D.C. Yeah, I'll be fair and impartial in my Trump trial. Put me in, coach. But with Trump, they can't do that. They say, hey, Mr. Juror, have you heard Trump call Jack Smith a deranged thug? Have you heard Watching the Watchers call Molly highlighter girl? Yeah, I have. Can you set that aside and be fair and impartial? They could ask the same question, but they're not. They just turn around and gag Trump. Trump can't talk about that. We have to gag him. Meanwhile, everybody else has free range.
But to go back to...
I guess Judge Millett has already asked these questions. Given all of the issues that are both before the court in this case and before the public in the election, it's hard to see how this portion of the restrictive order is going to succeed in preventing a trial in the court of public opinions.
Well, again,
I took her order to more be focused on protecting individuals, protecting witnesses from threats, from harassment, from fawning and efforts to positively motivate them and the like, not to shield the veneer. but you take a different view.
Well, no, I think I would agree that that is the principal motivation, certainly, shielding people from harassment, threats, and intimidation, both witnesses and other trial participants, and certainly that includes the line prosecutors handling the case. Again, special counsel himself is a slightly different case because he is both an individual trial participant and a representative of the institution, and so that's why we would say that merely mentioning him would not violate the order, that would not be targeted. Whereas in the debate, Your Honor, if...
Wait, I do want to hear that answer. I was going to ask a question, but before I do, I'm still struggling with how you distinguish. I mean, maybe the special prosecutor is in somewhat different place, but that does not mean that prosecutors working with him, assistant prosecutors, or whatever the title deputies, are not public figures themselves.
They are.
Would you agree?
They can be public figures for certain purposes.
Okay, so then it shouldn't matter. Why can't, on the debate stage, I guess now you can do that answer on the debate stage, why can't the defendant say A, B, and C, whoever is the prosecutorial team in the particular case,
Molly
biased,
and Jay.
Your Honor,
racist, anti-American,
They are.
I think in
whatever deplorable adjectives.
I think in context,
Yeah.
I think you'd have to view that as
Corrupt.
basically the meddlesome priest problem.
Partisan.
Why is he mentioning individual line
Unethical.
prosecutors, but for holding them up to scorn in the public and increasing the likelihood of their
Well, I
being
have to say,
targeted?
they make a good point,
They do. Make
that I'm not sure that, well, no one rid me of this meddlesome priest. Why not have a more First Amendment debate? You'd have to really make the showing.
Prove that.
If it's sort of the Godfather.
Prove it.
Someone get rid of the snitch for me, that's one thing. But you'd have to make that kind of showing.
high
But,
standard.
if a high level, if someone high up says, well, someone just make this problem go away, could he not say, well, someone just make these cases go away? It's a political vendetta.
Can he say
Let
that?
the American people decide.
Of course he
Can
can
he not say that?
Someone make these these cases go away, this political vendetta, that would be consistent with the order. That would not violate it, yes.
Not
So
violent.
tell me about your debate, what your view of, boy, it would be really hard in a debate when everyone else is going at you full bore.
So someone says Trump is violating the law from Jack Smith's office because he says somebody get rid of these cases. Somebody eliminate these cases. Just like Dan Goldman, a Democrat congressman from New York, said the same thing about Trump. Eliminate Trump, right? Can Trump say those things? And he kind of concedes that he could. Well then what is illegal then, Mr. Prosecutor? What then is the problem that violates the order that would subject Trump to sanctions and contempt under court?
And, your attorneys will have to have scripted little things that you can say.
Your Honor, I respectfully disagree that there be anything particularly challenging about a rule that says naming individual line prosecutors somehow, is too complicated, too hard to follow. He can say everything he
You
wants to
don't
say.
think you can name line prosecutors by name?
I think that would be presumptively an act of targeting. Context could suggest otherwise, but naming.
Well, what context do you need? I've got my debate here.
Yeah.
It's a matter of public record. You're receiving the you're paid by the taxpayers. And he can't say by name that
Even
person?
once you've appeared and spoken in open court in the case against him.
Our view is that is presumptively targeting within the meaning of the order, but
It's targeting because you're not the special counsel.
that's right. It's targeting because
What's your
naming-
definition of target?
It's our
Targeting, in our view, means singling someone out for the sort of negative attention that poses a significant immediate risk of their being a recipient of threats, harassment, and
But
intimidation.
negative is viewpoint-based, so the district court corrected, the reason she chose targeting instead of the language that you proposed was because she didn't want to make the order viewpoint-based and make it more defensible. But I think you're right that the targeting does raise a little bit of unclarity. And I wonder whether you comment on the proposed alternative that I mentioned to Mr. Sauer, which is if the order prohibited comment on any reasonably foreseeable witness or the court staff, but let me limit it to the witnesses, reasonably foreseeable witness because of witnesses' potential participation in the trial. Because
Broad.
one of the difficulties
Extremely
is
broad.
disaggregating the public figures who are in the political arena in other ways, writing books or, and who are anticipated to testify at trial here. Is that, does that do the work that you need? Does it pose different constitutional concerns that I'm not appreciating?
I don't think it poses any additional constitutional concerns. I think that would be a perfectly valid gloss on that portion of targeting. I do think it omits another important component, which is this concern about exposing people to threats, harassment, intimidation. So if the defendant were to say, not with any reference to their testimony, but say this person, is a coward, a liar, and a treason, and deserves a punishment of death, without any reference to what the substance of their testimony would be, I think that would still violate the order.
Except couldn't you, given context, if there's no other reason that this person's being targeted, you say the reason they're talking about that is because of the testimony. Whereas, when General Millett has written a book and has spoken publicly about his efforts to shield the world from the consequences of the defendant's conduct, that has got to be fair game.
Certainly fair game to comment on it. No, I don't think anybody suggests otherwise. But I think it's
so what's not fair game? So he can comment.
Yes.
And he can comment very critically. What can he not do?
Use the sort of inflammatory language that poses a significant risk that they will be subject to threats, harassment, and intimidation. So, I don't think the line between saying...
So he can totally comment on it. He just can't say anything that's meaningful. Okay, he can say something about it, probably like Mark Milley's amazing, and Mark Milley's like an American hero, and everything in his book is accurate. But if he says anything else that might be inflammatory, like anything, like Mark Milley's wrong, Mark Milley is incorrect, Mark Milley is a moron, Mark Milley is a traitor, like obviously those things like might be factual, but he's going to say they're all inflammatory. Mark Milley's opinion is in disagreement with my opinion. Like what?
Like this by the chairman of the Joint Chiefs of Staff is intolerable in democratic society, and saying on the other hand, this warrants the punishment of death is a particularly abstract or difficult line to draw.
Yeah. So it's comments that will predictably trigger the loyalist zeal, or what Mr. Sauer refers to as the heckler's veto. And that just took me a long time to figure out what he was referring to in terms of heckler's veto. But it's the triggering third-party conduct.
Read the brief, Judge?
What I would
in the brief.
tag as the loyalist zeal. That's what you're aiming at, is that the defendant can comment on all kinds of things, but when he does so in a way likely to trigger this excessive zeal, that is how you read the district court is targeting.
I'm full of zeal, man. I got a lot of zeal.
Barring that kind of speech.
Yes, right. And going back, Judge Millett,
I'm sorry.
Well,
Didn't interrupt you answer my questions. Go ahead, but then I do want to follow up more on this Mark Milley thing, General Milley.
Going back to the question about what can he say during the debate, I mean, I think it's also worth looking at some of the things that he said in TV interviews, and even in one of the posts that the district court used as an example in the order denying the motion to stay of what's permissible. So in that post, he's talking about the political bias in this prosecution, how it's been brought by the incumbent administration, and he says, at trial, we will 100% prove with evidence that that the election, that I won the election, and so forth. He can always say what every other criminal defendant in every other case says. Once we get to trial, I'm going to prove all this with evidence. The necessity to single out trial participants that have not been the subject of any sort of litigation, just as sort of a personal singling out just to put their name in the public, I think is presumptively an act of target.
So if I'm on J130, which is the General Milley post, can you tell me which parts of that were, because this was the day after General Milley did an interview about his book. It wasn't right after the indictment. It says nothing about the criminal trial or General Milley's prospective role or not in it. And so tell me, what of this, is everything okay except the punishment would have been death? Is everything else okay?
Yes, I would say so, and I think the important context to know when reviewing...
Is he wrong that, I'm not talking factually about this particular situation, about which obviously we have none of the details before us.
Well,
but is it wrong, at least
onto
historically, that, again, not talking about this conduct in particular, but some acts of treason were punishable by death?
No, that's not wrong, and the district court was free to...
Isn't that all he said?
Well, the district court was free to decide whether he included that language to make kind of the abstract historical point about what the punishment for treason was in times gone by, or was he saying it
well, what do you, I think for
to make a point, he's allowed to
talk
make
at least
a
about
point.
the need to balance, and it's not how I want my children to speak, but that's really not the question. And so the question is, what in here in this post, including the reference to historical capital punishment for treason, connects that to the criminal trial, connects anything about this post to the criminal trial, the criminal process, General Milley's potential or not, I have no idea, participation in the criminal trial.
So on its face, it doesn't allude to his testimony, but it's important
the timing, you don't have the timing. It's not like we do
have an important distinction in timing, is that the information about General Milley and his conversations with China, that all came out in 2021. The defendant had a reaction to that news then. He was not calling for him to be put to death, suggesting that death was an appropriate punishment. He started doing that once he was indicted.
Wasn't this the day after General Millett did an interview about his book?
Yes,
Comments?
yes.
Okay,
So it was in the news again, but his reaction to it, post-indictment, once he knew that General Millett was a potential trial witness, was very different than what his reaction was in 2021 when General Millett was not a potential trial witness against him. And so
pretty much once there's an indictment, he just can't, he can't, under this order, he just really can't say anything
Bingo. Bingo.
about folks who are either known or reasonably foreseeable witnesses.
Bingo. The judge just nailed it, right? The indictments freeze the playing field. Everything gets stopped. So they file it. Now Trump can't say anything. Now everybody else can't say anything. There's an investigation's ongoing until the charges come. And then now it's to protect the sanctity of the courts. So now Trump has to be gagged. And now none of these witnesses can be involved. And now everybody's freaked out that they might be indicted next. And so the whole game gets frozen and they can lay up trial after trial after trial, and they can fight for gags in every one of them. It's by design. Judge just nailed it. Yeah, no, exactly right. You can't comment on anybody. Milley, Pence, Pelosi, a whole reasonable panoply of different potential witnesses, reasonably foreseeable witnesses, are all brought into the fold. Trump is neutralized, essentially, and that's by design.
I disagree. I think
Can you say?
there's a perfectly comprehensible line between the sorts of things that use inflammatory and disparaging language that are
Can you say
likely.
anything disparaging
I think
about someone? You just said inflammatory, disparaging, so take off inflammatory.
How about
Is he allowed
disparaging?
to say anything disparaging about someone? We'll make it easy that he knows
Pull on that
he's going to
string.
be a witness now that there's been an indictment. Between now and the trial, obviously after trial is a different thing.
I think he can criticize them so long as he's not using either inflammatory language or attacking their credibility in a way that's going to shape how the jury sees them.
He can criticize them without attacking their credibility. How do you do that? Does anybody know how to do that? Well, I think he's I think Jack Smith has a great case, but has bad judgment. I think Jack Smith is, how do you criticize somebody without attacking their credibility? Jack Smith's ugly? Because if you call him deranged, well, it's his credibility. If you say Jack's like anything that is a commentary on, like literally, like anything that's a commentary on his performance is a criticism that attacks his credibility, isn't it? And he says you can't do that.
That's another example of trying the case in the media.
But I'm trying to understand with respect to these high public figures, they, like everyone else in the country, are protected against true threats. They're protected against criminal efforts to affect their testimony. They can be prosecuted for that. The defendant could be prosecuted for threatening them in violation of the criminal law. But when we step back and think about a protective order to protect the integrity of the proceeding, the mechanism is that their testimony would be affected.
I think
That's very hard for me to imagine.
I don't think that the test is whether any particular witness who is targeted will actually change their testimony or refuse to testify.
Or that it would be reasonably foreseeable that, because you're right, this is a prophylactic situation.
Gagging him, muzzling
I would assume that their
before there's a
testimony would
problem.
not be affected, that Mr. Barr, General Milley, former Vice President Pence. I take part of your position to be that there's a performance of their vulnerability that then would affect unknown non-public figure witnesses.
That's exactly right. There's a clear kind of knock-on effect. If you're a witness out there, and there are many, many witnesses who fall in this category, not public officials, no recourse to marshals or Secret Service protection. If they see that General Milley can be suggested he should be put to death, they see the former chief of staff can be called a coward, then they are going to absolutely be chilled. They say, why would I come forward and give the facts that I know about this case if the result is going to be that I'll be subject to the same treatment?
This is a very small question, and it reveals my lack of technical prowess, but is there any way preventatively to protect someone's technology? Like, let's say I'm a prospective juror. Can I be protected technologically from doxing?
No, you could have CISA and the old X, old Twitter censor you or something like that, Judge. But no, you can't censor a bunch of people. You can try to gag the president, which is what you're going to attempt to do. But my friends, that is really what happened. And I thought it was nice on the flip side on that to hear the judges, even the Obama appointed judges, kind of lacing into the government. How do we measure this? First of all, how can you connect Trump's statements to any actual harm? And the things that he says, aren't they kind of true in some instances? And can he say those things? And this government prosecutor had a real difficult time, I think, trying to tease out what the standard is. He says, no, he can't say anything that's inflammatory. Well, how do you criticize somebody without being inflammatory? It's kind of an impossible thing to do. So they're having a difficult time there. Now, we're still in front of 3 different judges who are all Democrat appointees, Obama appointees, Biden appointees. But the First Amendment is written pretty aggressively with a lot of historical precedent to support it. So we'll see what they do. My estimate is that they'll probably uphold some portions of it, maybe get rid of some other portions of it. But my guess is that regardless of what happens, this is just a temporary stop on the way to the Supreme Court. I think that regardless of the outcome, one side or the other will be appealing this up to SCOTUS, and then we'll have a final say that might impact the rest of the country. We'll see when it comes out, whether they accept the case, whether this happens before March, whether Trump is going to be limited in his free speech rights during the pendency of this trial or not is yet to be seen. But they're fighting hard. We'll be here to continue to cover it, my friends. Thank you for subscribing. Thank you for liking this video. Thank you for really inviting somebody to come over here and join us on our live streams. We go live weekdays. We'd love to have people come and see what's happening behind the scenes on these cases, because the media, it's just surface level stuff. They write an article. There's no real documents. They just kind of give you the headlines that they want people to believe. And we're trying to show everybody what really is happening behind the scenes here. And so thank you for inviting people to come and join us. Just invite them to subscribe. And we'll look forward to seeing you and them on the next one. All right, my friends. Well, we covered some good ground here today, and we now need to hear from you. We've got Chutkan's gag order under fire in the Court of Appeals. We're looking forward to that. We got Fani demanding that the trial take place in the Georgia case take place during the 2024 election. We've got Engoron claiming he's got absolute discretion for have professional interchanges with his law clerk. Ugh. And now, my friends, it's time to hear from you and to see what you have to say about all of this and more. We are running a little bit out of time, short on time on locals. So our locals friends, we're probably going to have to start up a second feed. So locals, hang tight. When our clock expires over there, we'll open up a second feed. But come and join us for our after party, watchingthewatchers.locals.com, which is where we do members only streams in the morning. We do weekend Saturday shows when we can do them, which is most of the time. And come and check us out, watchingthewatchers.locals.com. Also, Robert Gouveia is where you can sign up. RobertGouveia.com is where you can sign up for our daily newsletter. All the segments, all the stuff that we just covered gets packaged up, assembled into a daily newsletter that comes into your inbox. We'd love it if you signed up. We'd love it if you forwarded the newsletter emails that you get to friends and family. Just hey, this story would be awesome. So check that out, RobertGouveia.com. Now, we got some very generous donos in the house. My goodness, it's a beautiful Monday. And thank you, everybody, for sending these in and supporting everything that we're doing here. We got Glenn Croy is starting off the day beautifully with new membos. We got 5 new membos coming in courtesy of Glenn Croy. Glenn, thank you for sending those in. We got Aubin A. We got Nutter Brudder. Conservative CC is in the house. We got Judy O. and Brian E. all starting the day off as new membos over on the YouTubes. Thank you, Glenn. We've got this one. Mick is coming in. What's up, Mick? Coming in as a supporter over on the tubes. Welcome. Very nice to see you. Dim Sim is here. He says, hey, Rob, love from Australia. How cool is that? Shout out to our friends in Australia. Says, check out Wolves and Finance. Shout out to Wolves and Finance on the YouTubes. He does the same as you, giving out news the media won't cover. Sounds great, man. I love people who do that. So let's give him a big shout out. Shout out to Wolves and Finance. Sounds like a great channel. I encourage you to go check it out if you're interested in wolves and finance, which are both pretty cool things. And also, Alina Haba from Dim Sum in the house. Good to see you, Dim. We got Fred Pedamonte says, Rob, Fred and his dog Johnny say, Rob, your voice is so cathartic to me. I listen at 0.25x. I never want it to end. It just goes nice and slowly into the wee hours of the night, my friends. Well, Fred, that's the nicest thing anyone's ever said to me. Hey, another one from Glenn. Glenn Croy bringing in Harlan R., Mark L. We got a new member in the house. Guess who's here? Stop sniffing kids, Joe is here. We got Linda Hunter. We got Beaky is in the house, courtesy of Glenn. Another set from Glenn. We got John S. Patriot Chick is here. Kelly R. and Chuck all coming in courtesy of Glenn. Glenn, you're the man today. Bringing in some new membos. Thank you very much, Glenn. We got Knox Bierman's in the house. Says, happy Monday, all. Knox is an attorney. Says, this judge has Captain Bligh syndrome, along with a lot of other syndromes. Yeah, probably. This would be so frustrating as an attorney. I know, Knox. It's like, it doesn't even feel real to me almost. It feels like, honestly, like not even real. When he says stuff like, it's just a red herring, I'm not even going to address it. Next argument. You go, what? I put it in my motion. Like, you have to respond to that. He's like, no, I love her. I don't need to explain my feelings. Oh, gosh. All right, what's up, Knox says, and I have never heard the job description, principal clerk. And did you know that, Knox? It's so funny how he always refers to her that way. Principal law clerk, all capitals, PLC. Principal law clerk. And you go, geez. She probably was on him that one time when he's like, oh, my law clerk, you know, hey, let me introduce you to my law clerk. And she's like, huh? It's principal. And he's like, ah, sorry, baby. Don't get mad at me. Peter's here. Says, Robert, have you ever donated to a party knowing they're going to throw it in your face forever and bringing it up to show you are biased? Have you ever donated to a party knowing they're going to throw it in your face forever and bringing it up to show you are biased? Well, I mean, I haven't like intentionally sought to do that, but certainly I've made donations to political candidates and other things. And, you know, it's like, yeah, you know, stand by it. But I've never done it when I'm not supposed to do it, like when I'm a licensed, you know, judge or something, or when the ethical rules say that I can't do it. You know, I love contributing to causes and supporting things I care about, but not when it's illegal. Here is Swamp Saga City says, expert legal testimony isn't permitted. Yet that's exactly what the Colorado judge allowed in the primary ballot case. Unbelievable. And yeah, it's an interesting, it's you know, obviously different jurisdictions, different case types. We got a civil fraud case versus an election case and other, you know, context there. But yeah, you're right. I mean, basically what we saw out of Judge Engoron was that he was just finding things that supported his claim, which is why he went and he found the ethical opinion. He's like, my girlfriend at Greenfield can, in fact, make donos to things that, you know, maybe she otherwise wouldn't be able to donate to. So he was trying to thread the needle, and he definitely did that. Let's see what this is. Do we have some Venn diagrams? Here we go. Here we go. Here's a Venn diagram. We're trying to determine, John's doing some really heavy lifting here. Food for the week is $37.50. Political donations, $3,900. And it equals $1,500 in political donations. Okay, so we got some calculations happening here to help us tease out what's going on. And Knox says, remember, she is the one who wrote the opinion. That's the law clerk's job. I know, it's so true, Knox. And I didn't even point that out. It's like, I don't know if Judge Engoron wrote that one or if she wrote it. I mean, she definitely is like assembling it. That one kind of felt like he wrote it because he was probably irritated. But she definitely proofread it and assembled it all, for sure. And she probably offered him corrections. She's like, I think you should strengthen this statement up here, Judge. And he's like, oh, thank you for that. He's like, gosh, it's really nice when there aren't cameras on me and there aren't lawyers out here in our chambers where we can be nice and peaceful in private. They're doing their editing in his chambers. Oh, gosh. Or maybe at the gym. Oh, no. Voice says, called it. Engoron says, I did nothing wrong. We know you're guilty before this trial even started. Motion denied. Judge Arthur Areola Engoron. And was there did I miss a decimal point in there? Says John. I don't know what's going on. All right, Jason says, Engoron's Greenfield is a planet. Says, I think Engoron might have just gotten too close and got caught up in her gravitational pull, and now he can't get away from her. He's like her moon now. He's caught in her orbit. That's no moon. That's Judge Engoron floating around. That's no moon. That's an areola floating out there in space. Yeah, I don't know. And obviously this is not, we're not fat shaming here at all. She's just legally got some heft to her, right? Because she wanted to run for judge. And apparently she's got a bunch of extra dono money that she can send out to Democratic causes and doesn't even violate the law. She's so smart that that's what it is her legal knowledge is so astute that she can thread the needle. She can actually donate in violation of the law, but then deduct them like carbon credits off of her total dono amount. So she's actually under the legal threshold and not in violation of the law. Yeah. Yeah. And she's up there on the bench with the judge. That's what we're talking about. Here, what's up, Zach? Hey, Ryan Patrick stopped by. What's up, Ryan Patrick? Good to see you, brother. Says, smash that like button. Thank you, Ryan, for swinging by and saying that. And of course, Ryan's on YouTube. Shout out to Ryan Patrick. We got Jason Bees over here as a new supporter. Welcome aboard, Jason. Very nice to have you as a new member on the YouTubes. We got over on Rumble. We got our friends over on the Rumbles. We see Christian Fellowship Rob's in the house. We got B Green, Little Galaxies over there. What's up? We got B Green. Man, we got, hey, Jane, Catherine B's over there. Dog Digger's over there. I see Donuts, Mon down the fort. T-Tones is over there. Catwoman's over there. Super Buff is here. Ooh, we got Super Buff is over there. Sounds good. We got Rob says, hey, how will the videos released by Mike Johnson affect the J6 cases? And if the J6 cases is the J6 case, the Trump case, and if the J6 case is dismissed because of evidence, will it affect all cases against Trump? Marjorie plans to investigate the J6 committee. So in general, I would consider each case to be its own thing. So they're not all connected, right? Think of them independently, and each defendant's going to treat their cases independently, and whatever happens will be applicable to them independently as a general rule. But Trump can use this as evidence, provided that it is relevant and it's admissible, right? Essentially. So Trump could use it if he can find some evidence to say it supports and negates one of the elements of the crime, then he can certainly use it. But I don't think that necessarily it automatically, leads us to a particular conclusion. And I think it's good news that Marjorie plans to investigate the J6 committee. In fact, they should be investigated, especially for the deletion of the materials that were supposed to be handed over to the Republicans. It's gone. The evidence is missing. Why is that? The blind lawyer is over on the Rumbles. Says, what really hurt Fani's case is the Georgia case where the federal court is trying to question the voting machines. Yeah, the 2018 case from Judge Amy Totenberg that we read here on our channel says that really bolsters Trump's case. And I think that's a good point also. So Christian Fellowship Rob, I think that's right. The two things are kind of both things that Trump can now explore, which will be the J6 cases video and the evidence from the Totenberg decision, which we read here. If you have not watched that on wherever you're watching this, definitely watch that one. Okay, that's like a must watch because she chronicled not only problems with the machines pre-updates, but the pre-Dominion machines, also the post-Dominion machines, and she scheduled a trial in that case. And so we'll be covering that one as well. Good to see you, the blind lawyer. We got MAGA Hat Stays over on Locals. And Locals, we got a few minutes until we open up a second thread over there. So we'll get that queued up. MAGA Hat says, Ron was whining to Jake Tapper when that Trump was polling higher because the Dems were going very easy on him. Poor Ron. So much more abused. Well, I'm not really happy with Ron because I think he's on team prosecute Trump. In fact, I think that's his strategy at this point is to watch Trump get indicted, prosecuted, convicted, and then removed. I think that is where he's at this point. And so I'm not happy about that. I think he should be supporting, maybe not Trump, but should be supporting due process against partisan political prosecutions. And so we have, thank you for that, MAGA Hat. We got Chris E. Says speech that hurts people's feelings is not illegal. Mr. Sauer, or whatever, who sounds sour, they're making up new definitions of words, making our kids ignorant, but ignorance is no excuse of the law. Good comment, Chris. In fact, that's why we have free speech. It's to stop people from being prosecuted for offending other people. We want to say things that might offend other people, like your ideas are wrong, your opinions are bad, your policies are terrible, you are incompetent, you should not be a dictator over my life, you don't have control over what I do. Okay, and they say, yes, I do, and it's offensive to them when you say, no, you don't. That's the point of free speech. Your Department of Justice is corrupt. Your judicial court is illegitimate, or whatever argument you're trying to make. Good to see you, Chris. Chris says, sorry, my last message was confusing. I thought it was pretty good. But how do kids read our Constitution if they aren't taught cursive? That's a good question, too. Feels like it starts at home, mom and dad at home. It's true. Well, Chris, maybe you should teach your kids cursive. You know, I actually don't, so I know how to write in cursive, and I actually don't mind writing in cursive. Like if I actually have to write a lot, which I don't really write anymore at all if I can help it, which you should, because writing is important. And I think there is something to writing it. I think it does stick a little bit harder when you write it. But when I write it, and I get lazy, cursive just comes out. Now, the problem with cursive is that nobody can read it. Okay, nobody can read it, but I can read it. It's just like a big squiggly. Now, about the Constitution, I think it is written in block letters. And so at some point, if they can't figure out the cursive thing, maybe they can read it in regular text. But shout out to you, Chris, for figuring it out either way. And I think cursive is important. Just, you know, teach them that as well. The blind lawyer says Robert Hur looks like he's dropping the Biden cases. If true, that is even more evidence against Jack Smith. This shows the bigger problem of no accountability for bad prosecutors. Yeah, I think that's true, double standards. And they're just going to say, well, this is because Joe gave the documents back, right? He gave the documents back. And that is, oh man, we're going to have a little bit of a problem here on the local stream. All right, we're going to figure that out. Robert Hur, he says, it looks like this shows the bigger problem of no accountability for bad prosecutors. And that is from the blind lawyer. Good to see you, the blind lawyer. We also have some other comments. Let's see what we've got here. Let me see if I can fix this. Okay, we're going this direction on locals. We're going this direction. It's going to be a little bit different. We're using the built-in browser now. Hopefully you guys can hear me. Can you guys hear me over on locals? I think you can. All right, I think it's working. All right. So we got the blind lawyer explains, thank you for the dono. We got Glenn Croy says, bringing in new membos. We got Eric W., Mr. Otter Pockets is here. Zancy Pelosi, Cindy DeTore, and Pi Squared all coming in courtesy of Glenn Croy in the house. Amazing. Thank you, Glenn. Very generous today, Glenn. You're the man. Knox says, I've seen very angry family members show up in court with matching t-shirts showing their dead loved one or their innocent loved one, and I haven't seen a prosecutor faint yet. Yeah, Jack Smith and these deranged thugs over there, including Highlighter Girl, they are just being big babies, all right? Like, for real, just big babies. And they're actually not those big of babies, probably, maybe. I mean, they work in D.C., I don't know. But I think it's more about them just wanting Trump gagged. Like, they're not really that soft. They just want Trump gagged. And they're saying, our fifis are very sensitive to get it done. MAGA Hat says, they didn't protect Trump from threats, and there were numerous. Well, Trump is not on the inside circle. MAGA says, Dems threaten families all the time, which is also true. Good to see you, MAGA Hat. Goofy for Jesus is here. Says the J6 committee meetings during primetime have poisoned all juries everywhere. It's ridiculous to gag Trump and his attorneys. Yeah, it is, right? They've been slamming him for 3 years now as an insurrectionist, as somebody who tried to steal and wreck American democracy and all of the things. And now they say Trump, by saying that Jack Smith is a deranged thug, might be prejudicing the jury pool. He's undermining their credibility. Meanwhile, they've launched a full-on propagandized onslaught against him for years now. But it's all fair. Rocky Water is here, says panoply. Great word. Thank you, Rocky. Yeah, I'm trying to be a little bit more like Alina Abba here, you know. use some of those $3 words like contumacious and transmogrify. Panoply. We tried it. We'll see if I can hit it again. Rocky says, does the DC Circuit have a complete by date for their decision? Oh, you mean the Court of Appeals? I don't know. No, like in terms of a ruling, like when are we going to hear back from them? No, I don't think so. I don't think I have a deadline on it. And I don't think that there's really any urgency to it. I mean, I think they'll probably rule quickly on it, but no, I don't have a date. Good question there, Rocky. This one came in from Kevlar. What's up, Kevlar? We got this one. If the Supreme Court votes in favor of Trump, how do you think the media will cover it? Well, I think they'll basically the same pattern that we've seen previously. One, conservative judges are corrupt. They need to be removed so Biden can replace them, so that, Thomas has to go and they can replace him. Or the court needs to be expanded, right? That the court is illegitimate as it currently stands. It's not doing the will of the people. The DOJ has already indicted him and gagged him, and the rule of law is at stake because Trump appointed justices voted in favor of him, so it needs to be expanded. It's because it's illegitimate, right? Trump appointed Gorsuch and Amy Coney Barrett, and these people are weaponizing it against him. And so we'll see how far off I am, but I think I'm probably not. Hey, we got some merch coming very soon. We'll do a little bit of a sneak preview. Now, these are going to be launched this week, my friends. Oh my goodness, look. Okay, so we're doing some beta testing on some of the merch this week, and we got a first delivery that has already arrived, and the new hats are coming out, and we couldn't have a better model for these hats. And so this week, my friends, we'll get the merch store up. I got some final emails to send today. Look at these handsome boys, or the handsome boy wearing the two different hats with the new Watcher hats. And so these will be up on the store very, very soon. And in fact, I have one right here. I got one right here, baby. Woo! And it's going to be looking good. We're super excited about these. And so some more emails will be going out. We're testing it to make sure all the technology works. But this is a real handsome boy. And so, man, I can't wait to share more of these with you guys. It's going to be super fun. All right, handsome fella over there. All right, we got Alexandra is in the house. What's up? Alexandra is in the house. Hey, no questions there from Alexandra, but Alexandra, thank you. Very nice dono. Very nice tip. And very much appreciated. And, oh, Alexandra, here is the comment. Says, hey all, already posted this in the comment, trying to get it out there. Here's what we got. So a public service announcement here. Says last Thursday, Oconee County Deputy named Corporal Watts was injured, oh my gosh, after being shot in the head by a suspect fleeing a traffic stop. Corporal Watts is the father of a 2-month-old and is currently in critical condition, with loved ones very worried. If you're able to contribute to his recovery fund, it's more than appreciated. Man, I'm so sorry to hear that. We are going to be praying for Corporal Watts and his family and wishing and praying for a speedy recovery. He's in critical condition. It looks like we have a link here, my friends. So you might be able to just search for him, Corporal Watts. And the web address is serveandconnect.networkforgood.com. And it's just the Lucas Watts Recovery Fund. So look that up, Lucas Watts Recovery Fund. I'm sure it'll pop up. I'm sure there's stories about it. So check it out. Alexandra K8, thank you for sharing that with us. And we'll be pulling for him. We'll be sending some good energy and some good love and some good prayers over to the household in Oconee County, praying for Corporal Watts. Thanks for sharing that, Alexandra, for spreading that around. Appreciate it. This one came in from The Blind Lawyer. Says, public opinion can sway courts. Just look at the new Supreme Court ethics. This is why the January 6 videos are so important. Political pressure is turning against the courts. Well, of course, yeah. I mean, I think that public opinion is very important. And that's why Trump being able to speak about it is very important. That's why the First Amendment is very important. So that we can debate these things and argue about these at, during reasonable opportunities to do that. During all opportunities to do that whenever we deem appropriate. And I think it is important, they waged their war in the court of public opinion, and now they want to pull the ladder up, right? They've already climbed to the top of the mountain. They've already gotten everything that they wanted. Now they want to stop Trump from defending himself. by setting trials at unreasonable deadlines, meaning he can't even review the discovery, can't even prepare his case, and then can't even talk about it in public. Meanwhile, they've already launched everything. Rocky's saying the mic volume in the after party's overdriven a bit. Well, that's because thank you, Rocky, for the heads up. It's because we're using we're using the built-in browser feed because we ran over time, so I couldn't integrate it into our RTMP. So apologies for the overdriven mic, but that's on the platform end, not on my end. I didn't change anything. I'm just using a different software. So that's what's up. For those of you who care about the technicals, and I know there are some of you who do. This is the blind lawyer says, given the documents back does not negate the crime, which is strict liability. Again, the double standard. And I agree with this, talking about the Biden case versus the Trump case. Trump had a legitimate basis for being in possession of those documents. He was the president. He has the opinion clause power. He has declassification power. He has the Presidential Records Act. Pick one. Joe Biden did not have any of those. In fact, he was a senator. He shouldn't have had possession of those at all. Immediately illegal. But they're going to go in nonetheless and charge one and not the other. Word says panoply. I think it's panoply. You're right. The spelling is with a P-L-Y. Panoply. Panoply is the word. We got this one from the blind lawyer says, Jack Smith is just like Binger. They are not used to facing mass exposure and scrutiny. Prosecutors are protecting their power, same reason that no cameras can be allowed in the court. Right, they want to do all this stuff under the dark of night. Although Binger in the Kyle Rittenhouse case, I think that was all televised. That was all publicized. So we did get to watch that one on display. Hey, Ziggy Girl is here. What's up, Ziggy Girl? Thank you for this over on the Rumbles. Says, these are the arrows Trump is taking for our constitutional freedom of speech. If they can shut him up, they can shut us all up. Stand strong, Mr. President. 07 from Ziggy Girl. Ziggy, you're right about this, and this is why I think it's so foolish that Ron and all of these other so-called Republicans are not supporting him. Like, do they think that they're just not going to be in the crosshairs next? Are they serious? Unless they want to just play that game where they just, I guess, acquiesce to the DOJ. Like, if you're not going to stand up right now and say that the DOJ and what they're doing to Donald Trump is illegitimate, then by default, you think that they are legitimate. Which means when they turn their eyes on you, Ron, or on you, Haley, or on you, Christie, you're going to have to eat it. And when the politicized prosecutions come your way, you're going to have to default to their legitimacy, if you think that. Now, I think that they are illegitimate, and there's a lot of evidence to show that. But it's foolish that they're not also recognizing it. And I think they do recognize it, which is what's so dishonest about it. They know it, but it serves them right now. Okay, they can't come out and say it because then they would be supporting Trump. They'd say, yeah. Ron would have to say, yeah, he is a victim of a political prosecution. Sucks. Maybe you should go support him, I guess. Rather, he can just wait around and wait until Trump gets convicted and then argue that the party should not nominate a convicted felon. That's going to be his excuse. And it's foolish because they'll just turn the attention to him. If he does anything meaningful, okay, if he's just going to go and play ball with them and play their stupid game and not ever have to tar and spar with the FBI or the DOJ, okay, that's fine. Maybe he won't be under the same scrutiny, but that's not the candidate that we want. We want somebody who's going to go in and push back against the weaponized J6 prosecutions and against all of the double standards that we see. And if those guys aren't up to the task, then so be it. Thanks for revealing yourselves. Now we can see it. Thanks. The blind lawyer says, I am encouraging storming the ballot boxes and return power to the people. Well, that sounds a little insurrectionary, the blind lawyer. You better be careful about that. You mean storming the ballot boxes with peaceful political ballots? Or do you mean storming them like they did in those other states where the clerks of the city were stuffing the ballot boxes illegally and committing crimes? Certainly don't want to do that. But although you'd probably only get prosecuted if you were a Democrat. This is not legal advice. Don't break the law. Radice says, it's getting cold out here. This beautiful girl needs a hat to keep her warm. Indeed, she does. Definitely does. it is a little cold out there, and that head looks a little bit bare. And so we definitely got to get a nice hat on that lovely head. This beautiful girl. What a real good girl she is. Oh my goodness. Come here, come here, come here, come here, come here. Okay, good girl. Perfect. All right, so thank you, Radice. And that, my friends, is it for the amazing donos. Okay, panoply. We're correcting the emphasis on the syllable on the pronunciation of the word panoply. Panoply. All right, thanks for the correction. I think we all know what it means, hopefully. This, my friend, thank you for the very nice donos in the house. Let's say hello to our friends on the X platform and see who is joining us over there. If there is anybody tuning in on this beautiful day. We got 7 viewers. Okay, that's respectable. Elon's probably not joining us, but we do got the 7 who are here. You're amazing, and we love you. Danny McWilliams says Trump is not on trial. We are all on trial. Rob, your explanation of the DC gag order is very good. Thank you. Thank you, Danny. Fred says, hey, everyone always says you can't yell fire in a theater, but you can if the theater is actually on fire. Then it's a pretty good idea. Yeah, to definitely say something. George says you made it up into the 40s today. We got old drill sergeant says Jack Smith's office needs their safe space. Otherwise, their feelings might get hurt. Old drill sergeant says, I'll bet they'll uphold the gag order. Probably parts of it. Buffy Chetty says, keep up the good work. Wishing you and the family a happy Thanksgiving. And same to you, Buffy. Greg Burns says, how did they get all this power? Trump gave it to them by endorsing the wrong people over and over. Trump gave Chutkan the power? Or Jack Smith? I don't know. George says, little angry Engoron is a disgrace. This stuff would get so overwhelming and discouraging if I didn't understand Bible prophecy. Clearly states the right was going to be the victors. God bless you, Rob, and all the team over here. Thank you, George, for saying that. And hey, Julie's here. What's up, Julie? Julie Kelly, she's not actually on our Twitter thread, but she just showed up here on the Discover More feed. Says, it is truly stunning to hear 3 Democrat-appointed judges, including one appointed by Joe Biden, which he didn't recuse himself or anything, contemplate what Trump can and can't say under a gag order imposed by another Obama appointee at the behest of a Democratic Attorney General and Jack Smith. Hey-o! That's a swing and a home run from Julie Kelly, Banana Republic stuff. What a good comment. All right. You can see why she's so popular out there. But that, my friends, is what's happening over on the X platform. And thank you to everybody who joined us and followed us along over there on the X and left some comments. You can also follow us at Rob Govea ESQ. We also have a watchers community on the X platform, which is a lot of fun too. And we'd invite you over there to join us. Now, before we wrap up over here and go and get to the bottom of our vocabulary on our members only after party, we're going to pull up Panoply and we're going to listen to it. Panoply. We're going to listen to it. Watchingthewatchers.locals.com is where we are going for our members only after party. And we'll look forward to seeing you there. Oh my goodness. Look at these puppies who need some hats. Oh my goodness. I have 3 papitos ready to beta test the merch. Are there 3 in here? I can only see 2. Where's the third one? Is it tucked away in there somewhere? Where's the third puppy? I got 2 eyes there, 2 eyes there. It's probably buried in there somewhere. All right, well, shout out to the Sweet Potato. Thank you, Sweet Potato. We're getting super close to getting the merch ready. I just want to make sure it doesn't end up in like China somewhere. Every time you guys order something, it's in China. Sorry about that. But it is working. We're testing them out. And so Wood Chip Bill in the house says there's only one system of justice, and we're not a part of it. Yeah, I think as George Carlin said, right, it's a big club, and we ain't in it. So if you're in it, it's good. You can do whatever you want. You can have summers of love. You can insurrect the Capitol. You can pull fire alarm buildings and other things. But, oh my goodness, we almost missed a big tip here, a big donut. I almost missed that one. There's only one system of justice, and we're not a part of it. And you're right about that, Wood Chip. Good to see you, Wood Chip Bill. We've also got KX FMX 250 in the house. Oh my goodness. Wow, we got a bet made good on this one, and I'm happy to be the beneficiary of any wagers. Always happy to be the beneficiary. I love it when you guys wager with each other. Hey, KX250FMX is here. says, hey, Rob, I lost a little wager to John McGarvey the day of the Paxton kerfuffle. I'm settling up. Great to be back. That is just too funny. Okay, so that's from KXFMX. So when it must have been when Paxton was being removed or something, huh? Paxton stuck around. You thought Paxton was hitting the ground, hitting the door? KX? John said Paxton was staying. John won. And I'm happy to be the victor on this. John, thank you for the sending the victory over to the Watcher Fund, man. I appreciate it. And KX, thank you for being a stand-up person and honoring your bets. True integrity there. No matter what happens, you come back, settle up your bets. Pay your dues. Yeah, okay, John says it was whether he was removed or not removed, right? And John took not removed, and FMX took the removed. It's a nice dono. It's a very nice tip. Very honorable thing to do, and I'm happy to be the beneficiary of it. I love your bets. You guys should gamble about everything, as long as I get paid no matter what happens. It's great. Thank you, guys. Really, KX, thank you very much. John, thank you. Guys are super generous. Really awesome of you to do that. Okay, so let's see what else we got. I want to make sure I didn't miss anything, because I almost missed that one. And panoply, 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 from words, panoply. All right, we're going to check it out. I have no idea. All right, so we're going to continue on, my friends. Now, is there another one in the middle? Where somebody said I missed the eyes. Is it right here? Where is this little fluffer? Where is this little flurf ball? The heck is he? The heck did he go? I don't know where he is. It's one of those you know, I was never good. You know, remember when you were a kid and you went to the doctor's office and they had those like little magic eye things and they're like, spot all the differences. You know, I wasn't very good at those things. So obviously not working there. All right. And so, my friends, just two. Oh, okay. There's only two in there. There's only two in there. See? I knew it. All right. So that's from Sweet Potato. Panoply. All right, we're going to go figure this out at watchingthewatchers.locals.com. We'll come back with some better vocabulary for tomorrow. I'm not Alina Abba, okay? I'm not Alina, all right? I just, clearly, all right? I can't help it. I'm trying my best here, all right? But some of us are born, you know, not genetically the same. So, all right, my friends, that is it for us on the day. Oh, the other dog was taking the picture, Rocky says. Oh, that makes sense. He's, hey, smile, guys. No, again, do it again. Hey, look at the camera. I told you, do it again. All right. And so that, my friends, is it for us on the day. And we're grateful that you are here and with us. Of course, we're going to leave it there. It's going to be a busy week still. I know we've got Thanksgiving, but we got work to do, man. We got a lot of, corruption to root out here. These Democrats are out of control. Multiple Trump trials in all the different jurisdictions. We cannot let it rest. And so we will be back here tomorrow to get into it again. And don't forget, watchingthewatchers.locals.com is where we're going right now. But same time, same place tomorrow. And we hope to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.